Joe, let me know when you're ready. I can see you. Yes, it says attorney one, attorney two in court. All right. You ready? All right. We're on the record in cause number DF 11159111. Councils, will you please announce for the record?
Matt Garcia for the Movement, Dallas County Domestic Relations Office.
Melanie Henderson Love, Your Honor. I represent the respondent, Sarah Pond.
Okay. And the court is holding in front of it. Well, we're here set today on a first amended motion for enforcement filed by the Domestic Relations Office. Here, what I'm holding in front of me is an entry of appearance of attorney Melanie Henderson Love, as well as respondent special exceptions to the first amended motion for enforcement and respondent's motion to dismiss the amended motion for enforcement with prejudice, or in the alternative, motion to quash contempt and request for protective order, all being filed this morning at 9:23 a.m. I asked counsel for the respondent, which one would they like to proceed with first, and counsel said that their client would like to proceed with the motion to dismiss. Is that correct?
Yes, Your Honor.
All right. So at this time, the court will take argument from both sides.
Make my objection to this motion as not being timely filed, not giving us proper notice. Filing it this morning, an hour ago, doesn't give us proper notice. We at least are entitled to 3 days notice.
Okay. So would you like to proceed with the special exceptions?
I can proceed with this special exception, Your Honor.
Okay. Go ahead.
Well, Your Honor, because it's also incorporated in the special exception, some of the same things that we had in the motion. Yes, because I think that it's a fatal flaw what's been presented to Your Honor. Specifically, let me go.
You asking us to replete in the special exception?
I'd like for the case to be different.
What it says on the, what it says, respondent respectfully requests that the court sustain respondent special exceptions, dismiss movant's motion with prejudice, or alternatively order movant to replead within a certain time, strike all contempt-based relief unless a legally sufficient pleading is filed, and grant all further relief to which respondent may be justly entitled. So
The only thing they can do is ask for us to replete if you grant the special exception. They can't ask for the case to be dismissed first.
Your
right,
Honor,
I'm aware.
our response, our motion to dismiss is in response to what is on file. The first amended that was filed February 1st, 2025.
Okay, so what the court can do, because he is entitled to 3 days notice, the court can reset it with today being the first day's notice, and then you all can take it up at that time.
I would like for that, Judge, if we can.
Okay,
Thank you.
you're welcome. So let's proceed with the special exceptions.
Well, Your Honor, if we were to do the special exceptions, I would then waive my right on my motion to dismiss. And that's what I don't want to do.
Okay.
In my due order of pleadings, I think I could potentially waive that right, because I do think it should be dismissed, and I do think it should be dismissed with prejudice. But if the court is of the opinion that it's not, then I will proceed on.
Response. She's essentially, so with the due order of pleadings, the special exception has to be filed and taken up by the court first. If the court were to take up the motion to dismiss, she would waive her right under the special, well, her client's right under the special exception. She's of the opinion that the motion, the first amended motion, should be dismissed in its entirety. So in order to keep from waiving the special exceptions, she wants the motion to dismiss to be set and entertained at that time, giving you 3 days notice. Did I say that right?
Yes, Judge.
Okay.
We want to just set both at the same time?
I mean, we could.
Sure.
Yeah, we can do that. Let me see. And I'll give you all a quick turnaround date, because I think this is like the second or third time you've been here.
Yes.
Okay. So the court has as early as this Thursday. And then next week, Monday. Okay, what about Thursday? Well, technically, he doesn't have to appear because they're only doing argument. Yeah. So on the attorneys only have to appear.
I can do Monday, Your Honor, or Thursday.
Attorney Garcia, are you available on Thursday? He's not available on Monday. And are you all requesting this to be in person again? Because if you're only doing argument, you can do Zoom.
I'm fine with Zoom.
Okay.
Are you okay with Zoom, Ms. Catherine?
Zoom would be fine with me.
Might as well get used to it. It's not going anywhere. Thursday at, see, we can do, if you all are getting on Zoom, we can do it as early as you want to. We can do 8:30.
Are we
Just-
talking about Thursday the 5th or Thursday the 12th?
Thursday the 5th. I mean, you all can do it as early as you want to. My docket starts at 9, so if you all want to get on before then, we can do that.
I agree.
8:30?
8:30? Okay,
On the 5th.
yes. And I'll swear your client back in just for the sake of doing it for the enforcement, but you all can, you're more than, you can get on Zoom if you want to. I don't want to say that you can't get on Zoom, but you're not gonna be giving any testimony. Okay. Ma'am, would you come up? Good morning, how are you? Good, good. Would you please state your name for the record? Sarah Pollen, raise your right hand for me. Do you swear or affirm that the testimony you give will be the truth and the whole truth? Thank you. You may lower your hand. Ms. Pollen, you are ordered to reappear here on this Thursday, February 5th, 2026 via Zoom. That Zoom code is 688-044-0164. And I'm sure you may forget it, so your attorney is going to give it to you again, okay? So you're to appear here on that day, appear via Zoom at 8:30 a.m. Failure to appear may result in a capious warrant being issued for your arrest. As I stated, you're more than likely not going to be given any testimony. It'll just be argument from the attorneys. Do you have any questions about that? Okay. All right. Is there anything further for the record?
That's for you, Your Honor.
Okay, so just so the record is clear, we're resetting the motion for motion to dismiss, respondent's motion to dismiss and respondent's special exception to the first amended motion for enforcement. That's what we're hearing on that day. And you're more than welcome to file any objection or answer that you would like. Okay? Thank you
Your
all.
Honor.
You may be excused. Yes. All right, next we have DL 2000879 Thornhill. Good morning.
Morning.
All right, so. All right. So is this the motion for enforcement filed July 3rd of 2025?
Yes, and
So you filed it.
yes, ma'am.
Could you all switch so I don't get you mixed up? Thank you. Okay. All right, Mr. Thornhill, you were saying?
Yes, ma'am. I like to show that the obligation for fulfillment for Miss Bryant to watch the boys was unfulfilled. As declared by the divorce decree October 7th, 2020. We have an agreement for 50-50 joint managing custody where it's 1 week on, 1 week off. But it's several instances where Ms. Bryant was not fulfilling her obligation.
When you say fulfilling obligation,
She did
like
not,
bringing the boys?
she did not take custody of the boys. I was watching them on her designated weeks. She was out of town.
Okay.
And I do I ask I like to ask the court, uh can the court admit the evidence to may I admit the evidence to the courts that was admitted Thursday with Miss Lee?
Okay, so before we get there,
Okay.
because you filed a motion for enforcement.
Yes,
So a
ma'am.
motion for enforcement is a very technical motion, right? So it's pretty much where you're saying in the original underlying order, and I'm saying this to both of you because both of you have a right to file one, okay? In the underlying order, you're alleging that something was violated.
Yes, ma'am.
Okay, so when you allege that, it has to be very specific so specific in that she is on notice of what your allegations are. And I've taken a look at your motion, and it's not specific to tell her what she actually violated. So let me give you an example. It says on number it's not numbered. So are you looking at your enforcement?
Well, this morning,
You filed another one.
yes, ma'am.
Okay, so I can't entertain the one you just filed this morning because she's entitled to notice. You all were in here for the last case, and he said that he needed 3 days notice.
No.
Well, the last case,
Yes.
yes. Okay, so when you file something on the morning of, you can't bring it to court the morning of.
Right.
With you filing an enforcement and asking for contempt, she's entitled to 10 days notice. So today would be her first day on what you just filed today. Did you give her a copy of it?
May I give
Yeah,
now?
you can give her a copy of it. However, with you asking for contempt, you have to get her personally served. You can give it to her so she can see it, but she still has to be personally served. Okay? So I'm letting the record reflect that oh, I'm sorry. I'll go on the record and make sure I say that you tendered a copy to her. So as I was saying, if you go to page 2 of not that one, ma'am. It's the other one he filed, the original. Do you have that one?
Yeah.
Okay, so I'll give you an opportunity to take that out. Hi, Attorney Dale, how are you?
Good morning, Judge.
Good, good. Are you here on this case?
No, Judge, 10 a.m. Castillo, I hurried over from another court,
Okay.
so I can go in the back and get on Zoom.
Oh, yeah, sure.
Okay.
Yeah, they're in the waiting room.
Okay.
So yeah, you're fine. Yeah, you can use either conference room. Okay, I have it. Okay, so turn to page 2. Right above number 7, it says it is ordered that Cecilia Thornhill stay within the geographic restriction for residents and school attended for the minor children. Is it Cairo or Cairo?
Cairo.
Cairo, beautiful names.
Thank you.
I love the names.
Thank you.
Cairo, Landon Thornhill, and Egypt Nasir Thornhill. Okay, so when you say that, you have to say specifically what she did to violate that. So, I mean, I can't give you, I can't say too much without giving you legal advice, but you have to say what she did to violate that, right? And then on number 7, it says on date. You have to actually
The date.
put yes. It has to be very specific. Otherwise, if it's not specific, like you all just seen in that last case, the attorney filed a motion to dismiss, special exceptions. These motions are so technical, they get kicked out a lot just because they're not specific enough. And it's nothing against you all that are filing it. It's just because contempt is quasi-criminal where someone could potentially go to jail behind it. You have to make sure you follow it to the T. Because if I incarcerate someone and I'm not supposed to, I violated their rights and I can get, does that make sense? So with that, what you're going to have to do, Mr. Thornhill, you're going to have to actually replead and say specifically what she's done. Because as of right now, the way the law is written, she's not on any notice of any violations. Even if you read number 8, it says she failed to comply with the order. Cecilia Thornhill has violated several stipulations. You have to say what those are. Enroll the minors in a school outside of the geographic restrictions.
Specific.
You know what I mean? And then also has been neglected to take responsibility or care of the minors. The petitioner has taken responsibility for minors while respondent is out of town. Respondent has also committed perjury about not being served when records show that she cited that she has. So a couple of things. One, you don't violate the order if you don't pick your kids up. You violate the order if it's your turn to have the kids and they're not given to you, right? That's a violation. If she's out of town, and I'm not saying it's right? I wouldn't want any parent to feel like they're picking up the slack for the other parents. So I would encourage both of you to pick up your kids like you're supposed to. But if one or both of you decide, I'm not exercising my possession this week, you don't have to. I would just encourage you when you do that, communicate to each other ahead of time. Hey, I'm going to be out of town. I'm not going to be able to get the boys this week. I'm going to be out of town. Do you have something to do? If he has something to do, make other arrangements to make sure that someone is watching the boys. And whoever the arrangement is going to be with, make sure he knows who they are.
Can I respond to that?
Hold on.
Okay.
I don't want it to get in a back and forth, right? Because I'm not here to counsel you all per se. I just want to make sure that you understand your rights and duties under the order.
Okay.
Okay? Now, not attacking him. What is it you want to say?
To you.
Okay.
There has always been an arrangement made. Whenever I go out of town, it's not to just go out of town. It's always for work. Because at the time I was a catastrophe adjuster. So I would go to different states to adjust claims in that state. And this last particular time that he's talking about, I talked to him, he agreed, and I dropped the kids off to him before I went. So it was never like I just left. It's never been that.
Okay.
And then he even gave evidence of me sending him money for those weeks that he kept them for me.
Okay, but you understand his concern, right? He want week on, week off. That's a lot of time to have a kid, especially on the other person's weekend, right?
Yeah.
So-
Your Honor.
You understand his concern.
No, I understand that we're in court, but there's no concern truly because these are things he agreed to before I even left.
Did you agree to that?
No.
I have the.
Hold on, I heard from you. Let me hear from him. Go ahead.
So on a particular instance, she had left without me being notified, and I was denied my first right of refusal. She had her sister watching them. And then I found out from the boys that she's out of town and their aunt was watching. And then, of course, I'm going to agree to get them. But may I ask a question?
Yes. While you're here, I want both of you to ask all the questions that you have, and I can answer them with, as long as they're not legal advice. If it's, process, legal, I would rather you ask while you're here than to walk out and not know or understand. Go ahead.
With with the enforcement, I have up until 2 years after the boys are 18 to bring my case. Is that true?
For possession and access.
Yes, that's what I'm asking.
Yes.
So I do have grounds because I'm just asking if if we agree to an obligation and it's signed by us and sealed by the court, we have to abide by what the court says, correct?
Yes, but I also want to say this though. This was an agreement between y'all.
No.
No, the agreed judgment, the
Okay.
decree.
Yes.
So the underlying order was an agreement between you all. Life changes, okay? You all can agree to something different if you want to. The court order is just there in the event there is a disagreement. So you all have at least a baseline to go on, right? But in the event that you all want to say, hey, we're going to move away from that, you can do it.
Mhm.
And I actually encourage you all to do that because these are your boys. You don't want me to tell you what to do with your boys because I don't want anyone telling me what to do with my son or my daughter.
My whole notion for coming to court is if I'm the parent that has the children the majority of the time, I should be the custodian if I'm having them the majority of the time anyway.
Oh, I see what you're saying.
If I'm spending resources of mine that she'll decide or not decide to get to me depending on a situation or mood, that's my overall outcome, is to be the custodial because I have taken on the responsibilities for the time. So everything that comes with that, choosing what school they go to, because the school is not a school they should,
And how old are they? 10 or 9?
9 and 12.
9 and 12. Okay.
And also this is a time before she had said she was going to give me custody because they were acting up in school. And statistically, we understand how fathers can raise children versus, the mother when it comes to discipline. So, and that was reneged on. So I'm just doing what's in best interest for the boys as far as their behavior, as far as the school they go to. And if I'm the one doing the majority of the work, because as time has shown, I have had them in duration longer than Ms. Bryant, but we have 50-50 custody. I should have everything that comes with that. The tax benefit that I don't get anything of, it's 50-50 custody. We have 2 children, but she gets both tax benefits. And I'm the one keeping them the majority of the time and doing the majority of the duties of their upkeep. But yet she has all the benefits. She gets to pick the school, she gets the benefits, and that is unjust because she's going against what we agreed on and what the state specified. So that's my overall outcome, is to just point out the inconsistencies of Ms. Bryant, where I haven't been absent. I've been here since day one, since they dropped. So
Your Honor,
I
that is correct.
Okay, so
I understand, like, for example, I have to specify in specificity, like on August 1st, 2021 through August, the defendant was not present to take on the kids. You're talking about that specific.
yes, but let me also say this because if I'm hearing you correctly, what you're trying to do is change the underlying order so you can get what it is that you're requesting.
Or both. I want both, the enforcement and what I'm requesting.
Okay, so the enforcement with what you're wanting to happen, the enforcement wouldn't necessarily get you there.
Okay.
You would want to modify the order, and both of you have the right to modify an order. Like I said earlier, life changes, circumstances changes, kids grow up, they get older, they get involved in activities. You may want to put them in private school versus public school. Like all those things are going to happen. And when it does, either of you can request that modification. You can file a motion to the court, get the other person properly served, get it set to have a hearing. And then you would let us determine what's in the best interest of the child or children in this case, based on what you're saying. So that's what you would be asking for. And ma'am, you can ask for a modification too.
Okay.
However, let me just reiterate this. These are your boys. These are your boys. So the more that you all can come to an agreement based on their best interests, where they're at right now, that's always going to work better for them than a court intervening and telling you what to do. Because if I have to get in it, my associate judge has to get in it, we're going to go based off of the evidence. And evidence is also testimonial too, right? And in this case, your oldest child is 12. He is able to
Decide.
speak to us. Well, it's two-pronged. So the law says that at the age of 12, we're required to talk to him. And we take into consideration what he says, but it also has to be in his best interest. And we take those interviews very, very seriously. And if we make a decision based on the things that we're hearing and the things that you all are talking about, it may be a decision that neither one of you like.
Oh,
You
gotcha.
and you may walk out of here more disappointed than when you walked in. So I said all that to say, as best you can, co-parent. Try to figure out what it is these boys need. Now, if that does not work, it absolutely is like, I'm not budging. I don't care. I'm not doing it. Then in that situation, you come to court. But I would just recommend you don't do it prematurely. Like actually give it a good faith go to try to work it out. And both of you keep smiling at me. Both of you keep grinning at me. And and I know what you're probably thinking, like, oh, he's not gonna listen. Oh, she's not gonna listen. Somebody has to listen because Cairo and Egypt, they don't, at the end of the day, they do not care about any disagreements you all are gonna have. They just want you all to get it right. It's parenting, it's hard. Trust me, oh my gosh. I could go on all day to tell you how hard it is raising a 16-year-old boy and a 6-year-old girl.
Wow.
It is difficult. Parenting is one of the, when you're a present parent, it is hard. So I can understand everything about you all not wanting to work together. It's hard. Sometimes the boys are acting up, and because I know they're going to get on your nerves. I know they're going to get on your nerves at some point. They do. They're kids. You probably don't. It probably doesn't get on your nerves as much because you're a guy. But it may get on her nerves a little different. You may be a little bit more tolerant, like I said, because you are a guy. But because of that, y'all have to work together. Try to work together. That's all I can ask you to do. Try to work together to see what you can come up with. You two have a conversation. Then have a conversation with your sons. All 4 of you have a conversation. This is your family. Your family. If it does not work, then come to court.
We'll be back in here.
Then come to court. Modification.
So you saying you don't want to try even a try?
I definitely want to, but it's not about that. It's about control with you.
Well, I'm gonna control both of you right now, and I'm going to say, I want to see the 2 of you try to work together. And guess what? Y'all are here. I have 2 conference rooms out there. You can start right here. I don't know how much time you have. I mean, I'm not holding you hostage. But while you're here, talk. Get a piece of paper. Y'all need a piece of paper? Y'all need a piece of paper?
I have paper.
I'm so serious. You know what? Y'all gonna use my paper. Here, you come get this. Mr. Thornhill. Oops, I'm sorry. Mm-mm. Here, here. You need a longer piece of paper. Come on, come on. You're welcome. I need the two of you to go in that conference room and talk. Y'all go in that conference room and have a conversation. Try to see what agreement you can come up with. And you can get as creative as you want to. If you all just, it's week on, week off. If you say we want to do 3 months on, 3 months off, 6 months on, 6 months off, let him choose the schools. If he believe they need to be in a better school, you all can come to any agreement you want to. Talk. Please.
I will.
Can y'all do that for me while you're here?
I agree.
When it comes to, I gotta specify something.
Okay, go ahead.
A lot of times men have responsibility with no authority, and that's the official definition of slavery. So if I don't have any authority, I'm stating a factual statement.
What do you mean by authority?
Being able to decide what direction the car is being driven. Two people can't drive one car. So when she said it's about control with me, I will admit yes, because I have shown that I make the proper decisions for the boys, for myself, and for the betterment of my family.
Mm-hmm.
So there has to be a head, there has to be an authority, there has to be someone that does have control. We can talk about it, but at the end of the day, it has to be one person with the decision and the other person has to cooperate. With the co-parent, it has to cooperate. But if it's just she wants to do her thing, I want to do my thing, we'll be back. So with the statement that you said, that is exactly what is needed because you have had control. You have had the choice on what school they go to, where they live, and everything that comes with that.
Where they live with you as well.
No, I'm saying on paper. So I'm saying, since you have left them to me 3 times
Yes.
before the divorce, you left
So
them.
why are you even counting that? We were
Because it was 3 times that you left them with me.
Well, I went to work.
I
Are you
understand.
hearing him though?
I
I
understand.
hear what he's saying.
Okay, so you all need to talk because what I'm hearing is not that he want to control you and tell you what to do.
Oh, because you don't know him.
No,
I don't know either one of you.
She's
So I don't know either one of you. What I'm saying is, just like you have valid concerns, that's a valid concern. Y'all need to have a conversation.
And I agree to it.
Seriously, have a conversation, but don't just, and I'm saying this to both of you, don't hear each other out for the sake of trying to respond. Hear each other out for what is not being said. Because he just said a lot right then.
He always says a lot. I get
No,
that.
not like that.
No. I know what you mean.
Yeah, he said a lot. Just, you understand what I'm saying?
I get what you're saying, but I haven't said anything, so you don't really know my side. We have.
I don't want you to think, let me say this. I don't want either of you to think that I'm taking anybody's side.
Right.
I don't want you to think that. I don't have a dog in this fight. Cairo and Egypt are the only 2 people that matter in this situation. Your feelings don't matter. His feelings doesn't
I
matter.
agree.
It is the boys. So if you put aside how you all feel about each other, what failed in your marriage, and you strictly only think about them, you will see things a lot clearer. Trust me, I was a single parent for 9 years. You will see things a lot clearer. And I can tell you, the person I am today, I didn't see it back then. But now that my son is 16, I see it. And I see some things that I could have done different. And if I had been more open to things, my actions back then would have been a lot different. Yes, ma'am.
I agree with you, and I'm actually very open. I'm open-minded. That's why he even said that at a point I was going to allow the boys to come with
Mm-hmm.
and live with him. But when I've learned basically the teachings that he's giving them and the way he's steering their mind, since he is the driver, that's not something that I agreed with or that I agree with. So that's why I haven't given him the driver's seat, because he feels like women are inferior to men. And he's teaching my boys that
Objection.
he also I'm talking.
Let us speak. I let you speak. Hold
And
on.
he also has taught them that Black women are the lowest level of women and they should not deal with Black women.
That's a straight up lie.
That is
Okay.
100% what
May I
my
respond?
children told me.
Okay.
And that's not the only thing. It's been several things where he doesn't have the boys in our best interest. Like I put them in football. They begged me to be in football. I put them in it because he doesn't agree. Because he literally told me and told the boys to tell me, because I'm the one that chose the team, he wasn't gonna take them to any more practices. When this was like towards the end
This
of
is
the
all
year.
fraudulent. You're just making stuff up. I took
No,
them.
I am not.
They have not missed a practice.
I'm
I
not
just
I'm not done. At their homecoming, he did not even let my Egypt get his awards. He snatched, as soon as the game was over, he snatched them from their celebration because he said it took too long. He was there too long. He said he was not taking them to any more practices. He held their football gear hostage. The team mom had to call him to even get the football gear because he wouldn't give it back to me. So there are several things where it sounds good, but in reality, it's strictly about doing what he wants to do. It's never been a compromise. Because when I was out of town working and I asked him, hey, can you put the boys in football? He said, I'll see if I have the time. I said, I'll pay for everything. You don't have to worry about it. I'll pay for it. Because when I do go on deployment, I make good money. He never put them in.
Are they still in football?
No, the season is over.
Okay. Are they going to be in
Can I
football
respond
again?
to
Yeah.
the-
Hold on, hold on. One.
allegation?
Hold on. See, and that's the thing. I don't want either of you to feel like you have to defend yourself.
But if
Because I'm
she's
hearing-
accusing me, I have to defend myself.
No, but you don't. You don't. Neither one of you have to defend yourselves.
If I was to accuse her of the factual things that are on paper,
Mhm.
she would be in an uproar and have an excuse for it.
And you know what? That may be true. Here's the deal though. This isn't a hearing. This is just me choosing to hear you all out, because with you filing this enforcement, that tells me you have a concern.
Mhm.
And with you filing the enforcement and it's not correct and it's not proper, at least while you all are here, I want to explain to you what your rights are under the order. Like I said, at the end of the day, these are your boys. You both get to decide the rearing of them. You're not going to always like what the other person does. And this is what I want you to put on paper. Whatever it is she wants from you or you want from him, you have to ask yourself, even if that other parent is doing something that I don't necessarily agree with, is it illegal? Is it something immoral? Is it something harmful to their psyche? Is it harmful to them spiritually, emotionally? And then you gotta be careful with that, because if you all are different religions or you believe in something totally different, you have to be willing to co-parent with that other person and voice your concerns in a way that is not accusatory, because the boys are seeing, hear me out, the boys are seeing the disagreement. And as they get older, trust me, they're going to see who the problem is. Mm-hmm. Something you said, I want to encourage both of you not to ever do this. Stop talking to these boys and telling them to say, your daddy said this or your mama said. Stop doing that.
Yes.
Stop doing that. Both of you, stop doing it.
I don't do it.
I'm sorry. Both of you, do not do that. You're not making the situation any easier when you do that. These boys need both their parents. They need their mama. They need their daddy. They need both of you, and they need both of y'all to get along. You do not have to like each other. You do not have to agree with what the other person is doing. And to be quite honest with you, I want to applaud both of you for being good parents, because if this is the concern that you all have, you're in pretty good shape.
I haven't
Because
addressed them.
no. What I'm saying concerns, let me tell you the concerns that I see that are big concerns. Kids getting abused physically. And
Ma'am, that's happened.
what
I have documented.
hear me out.
See,
When I say abuse, I'm talking about CPS intervention where
Yes.
they're in this courtroom taking the kids from both of you. That's not why you all are in front of me.
CPS has been called from her.
That's not what I said. Calling CPS is
That's
different.
different.
Hold on. Calling CPS is different from CPS intervening. There are situations, I have cases on my docket right now where CPS is the custodian of children because the situation in the home is that bad. You all are not there. And I'm not minimizing either of your concerns. I'm just saying that you all are great parents. These boys are healthy. You haven't come in here and
Thriving.
said anything about having, I mean, you think of the worst, the things that you see on Facebook or on social media, or you read in the paper, kids having lice, kids having all of these maggots in their home, no food in the refrigerator. Neither one of you have come in here and said that is what you are dealing with. So because of that, hold on, because of that, you all are great parents from where I'm sitting. You're great parents. I just want you to be better parents.
May I speak? And
I'm not going to speak to either one of you anymore because I don't want you to feel like you have to prove anything to me.
But she made
No,
she made felonious allegations.
She may have, but you telling me is not going to change my opinion of you. I see great parents.
But that's the thing. It has been time when they haven't been fed. It has been time when they have been abused.
Okay.
It has been time. I just haven't been able to speak on it. But she has abused them. She has had it to where I had to order DoorDash because there was no food in the house. My sons be telling me they have to make their own food because she just will not. So when you say that we're great parents,
Y'all are great parents.
you're gonna have to.
You're both great
If I
parents.
was to comb through the practices
Please do.
and even with her partner
Please.
abusing the children, and it's just gonna be steady unaccountability. She didn't do absolutely nothing ever.
Well, here's the deal. You all have come in here and you put me all in your business.
Mhm.
So since you put me in your business, I'm going to stay in your business. And I'm telling you right now, you all are going to go out there and you're going to have a hard conversation. I give you 30 minutes, but you need to report back because I need to hear some progress. Even if it's one step, I need to hear some progress.
It can be 5 minutes, it can be 2 minutes.
No, it's going to be 30 minutes.
That's
It's going to be 30 minutes because that gives you all plenty of time to come to at least one agreement. One, at least one.
There's only one to come to.
Hear me out. One agree, and it's not one because it's two of you. If you were the only parent, this would be an easy decision.
I
If
feel
you
like
were the
I'm
only
parent.
you and he need you hear his concern, okay? It's here's at the end of the day, it's two of you. So it's not one decision. And hold on. I don't need to hear from either one of you anymore. It's two of you. Both of you are going to have to compromise. Both of you are going to have to give up something because that's what a compromise is. No, both parties are going to be happy when it comes to parenting. Put yourself to the side and do what's in the best interest of these kids. And come to some agreements. Do you all need your original court order so you can start from there and see what you all want to change from there? Because you can get as creative as you want to with what you want to do. Do y'all need that? I can print it for you.
I don't need it. If he needs it, I don't.
You need a copy
I
of
don't
it?
change anything.
You need a copy of it? Hold on. Do you need a copy of it?
No, I know exactly what I was.
Okay, hold on. Do you need a copy of it?
Yes, please.
Okay, so I'm going to make I'm gonna print one out for you anyway, Mr. Thornhill, because I need you all to look over this, like give it a good look. Because for you, it may just be one thing right now, but when you actually look at this, you may say, you know what? I might want to change that too. And in 30 minutes, you all have the opportunity to talk about it. Because we're not walking out of here today without you two having a conversation to do what's going to be in the best interest of these boys.
We don't know how to have a conversation. We don't.
Well, you know what we're going to learn today, because I have time. I have other cases that I'll get to in between that. We have time. You all showed up today, so obviously you needed my help in some form or fashion. So I'm gonna give it to you. Why isn't this printed? It is on. There we go. And now that I think about it, the law has changed. So this order that you all have of 2020, the law has changed quite a bit since then. So now there's a specific right that's separate from the person who determines the primary residence. It doesn't logically follow that the person who determines the educational decisions is the person who the kids live with primarily. That can be two different people, or it can be one person. And I said that for a reason. All right, so.
Quick question.
Yes, ma'am.
So is this case thrown out and a new one is starting, or?
No,
Nope. Nope. So,
my apologies.
okay. No, it's not thrown out. So his enforcement, we can't proceed today on it, more so because of technicalities.
Mhm.
But while you're here, I'm taking it upon myself to make sure that you all have a conversation, because I do not want these boys to spend the remaining years of their life tied up in court. And I've seen it happen. I've been on the bench 3 years, and some kids have literally grown up in court. The cases I've seen, they started as young as months old, and now they're 13, 14, 15. Could you imagine your parents not getting along for all those years? I don't want that to happen with 9 and 12. They need to have good memories. If all the memories they have of you both is fighting each other and being tied up in court, that's what's going to set them up to not be effective adults more than any experience, because you two are their first teachers. You're the first woman they'll ever love. You're the first man that they'll ever trust. So here's your copy. Here's your copy. Take that piece of paper that I gave you Write down on one side, I need you to write down, and y'all have to listen to this because I'm giving you very specific instructions. Make a line down the middle of that paper. What your wants are. But read that first because you're going to have more than one want. Trust me. When you start reading what's in that court order, write down on one side what are your wants. On the other side, you need to write down what you're willing to give up because it's a compromise. If you want for the boys to live primarily with you, you have to also say what you're willing to give up on that other column. If you read the order first, you may change your mind. If you say that you want the boys to live with you or they can live with daddy, but you also want to give this up, you all gonna have to come to an agreement. I need to see something. So it is 10:36. You have 30 minutes. If you need to come back in here before then, just peek in here, give my bailiff's attention, and he'll bring you all back in here. Y'all took off work today? Y'all free? Oh, you already went to work? What about you? Oh, so y'all have time too? Okay, so go ahead and go in the conference room. Sure, you need a pen. Well, he probably already have one. Okay.
This answered your question.
My question was, did you need a pen?
No, ma'am.
Okay. Whichever conference room is open, you all can go in that one. Good morning, council.
Good morning. I'm actually a paralegal for Thornton Day.
Oh, nice to meet. What's your name?
Linden.
Lyndon. Nice to meet you, Lyndon. You're welcome. Yeah, you can. And Arnell, they're going to go into one of the conference rooms that's open.
Yeah, they're getting married, so I'm gonna put them up here.
Oh, okay. Yeah, I do.
Thank you so much.
I just need your name.
Remind myself to write down 2026. I've been writing down 2025. Mm-hmm. Here you go. Have a good day. You're welcome. No problem. Okay. Let me see. Joey. Yeah, I'm gonna go ahead and pull them in, and then I'll do the wedding.
You did.
Is it okay?
Where's the, sure, that's what.
Okay. Yeah,
You went downstairs.
Good morning.
Good morning.
How y'all doing?
Good morning.
All right, so this is cause number DF 2105135, Armas and Castillo.
Oh,
Oh, I think you all are on mute.
That's correct, Judge.
All right, so I see. Have you all had an opportunity to speak about this case? I mean, you should have already spoken before today, but I just figured I'd ask.
no.
Okay, would you like to speak?
Yes.
Okay. So, Attorney Adamson, who do you represent?
De Armas, Israeli.
Okay. And then state you all intervened?
Yes, Your Honor.
All right. So let me put you all in a waiting room. I mean, excuse me, a breakout room.
That is. Amen. Yes.
You should receive a prompt to switch over to that room.
Got it.
Okay. All right. Good. I don't know if I have. Oh, yeah, I changed 400. What I do? Yeah, I don't have change 400.
Okay.
Cornelia, you have change 400.
Oh, maybe I have changed.
Okay.
Okay. Okay.
Let me bring in the next.
16.
He's got it.
Okay, perfect. Thank you. Good morning. How do you say your last name, sir? Is it Litchi?
Lee G, yes, like Bruce Lee and the letter G at the end.
Ligi. Okay. All right. So I have one case that's in front of you all. I'm getting ready to perform a wedding, and then I'll check back in with you all, okay?
Congratulations on the happy couple.
Yeah.
They said thank you.
Thank you so much. Lovely.
Okay.
This yours?
Yes,
This yours?
yes, yes, sir. All right. Are you all exchanging rings today too?
Yes, sir. Yes, ma'am.
Okay. Uh, Okay. Mohammed, is it Riaz?
Riaz, yes.
Riaz Abasi?
Yes.
Okay. And Arshia?
Arshia
Arshia
Jahan
Jahan
Begum.
Begum?
Yeah.
Begum.
Begum.
Begum. Okay. Y'all want to come forward?
Yes, ma'am.
You like video?
Yes, please.
Okay, she can do it for you.
And a picture of.
Oh, yeah, absolutely. We can do a picture here, or you can take them, I can turn the screen off right here so you can take them over there.
Okay.
I'm sorry, my Valentine's Day balloons aren't up yet. They come up next week. Look. Okay, so one right here, one right here, you're gonna face each other. Hold hands like you're in love. There you go. Yeah, like that. Joy, great. Yeah. Okay. We are gathered here today to celebrate in holy matrimony, the ceremony between Mohammed Riaz Abbasi and Arshia Jahan Begum. The two of you have signed and agreed to waive the 72-hour statutory period. Is it your agreement to proceed with your ceremony today?
I would request that if you can wait the 72 hours. If you work with them.
Okay, no problem. And that's why I signed the waiver here for you. All right. Marriage is sacred. It is a covenant under God, and it should be entered into soberly and honestly. Mohammed, do you take Arshia to be your lawfully wedded wife, to love, honor, cherish her, be honest with her through sickness and in health until death be you part? Arshia, do you take Mohammed to be your lawfully wedded husband, to love, honor, cherish him, be honest with him through sickness and in health until death do you part? Okay. Okay. Mohammed, you're gonna go first. You're gonna take the ring and place it on Arshia's left hand of her left finger of her left hand. There you go. And repeat after me. With this ring,
With this thing,
I be wed.
I'll be there.
Okay. Arshia, your turn. You're gonna take the ring, place it on the left finger, with left hand, repeat after me, with this ring. With this ring. I be wed. I'll be wed. Okay, and place it. All right. Well, by the power vested in me and under the authority of the state of Texas, I now pronounce you husband and wife. You may kiss your bride. Congratulations. You're very welcome. Okay.
Yes.
Yes.
I don't think it's a good idea that those two are.
Well, be fine. You're here. You're welcome. You're welcome. If you want to take a picture.
Yes.
Would you like for me to turn this
Yes.
off so you can take a picture here?
Yes.
Okay.
Can we have a picture with you?
Absolutely. On the bench, I'll grab it. Okay.
Thank you, ma'am.
You're welcome. Have a good day. Thank you. Okay. All right. Okay, they're back on this one, Joey. Okay. On the Castillo Armas case,
Yes, Judge. Mr. Adamson's talking to his client regarding the contempt portion. Oh, he's back.
okay,
Um,
all right. Let's see. Okay, Attorney Adamson,
Yes, ma'am.
were you all able to come to some agreements?
We were close. I think the OAG's numbers are great. It's going to be just under $2,000 a month. The only question is the OAG isn't pursuing contempt, which I understand we are. We would forego the requested 48-hour, serve now type thing, but we want that guillotine hanging over so that there's a little more alacrity with making payments.
Okay. And just so I'm clear, this is the May 14th, 2025 enforcement?
I don't have that date in front of me, Justin, do you? I can pull it up.
This is the most recent one I see.
that looks like correct, Judge.
All right,
Yes. Mother's
Okay.
filing May 14th.
all right.
That
Thank
is
you.
correct, yeah.
Thank you. So, which issue does the court need to decide on?
Whether or not there's contempt would be my only, if Justin agrees, I think that's the only outstanding issue is whether or not there's going to be a contempt finding with the sentence stayed.
Okay, so this is what we're gonna do. We're gonna go on the record and you all can outline the agreements that you have and I'll just listen for testimony regarding the contempt portion. Fair?
Yes, ma'am.
Okay, both sides ready to proceed?
Yes, ma'am.
All right.
Yes.
All right, Mr. Castillo and Ms. Armas, would you all please turn on your cameras? I just sent a prompt.
Ms. De Armas' microphone isn't working. She had to chat to me. I don't know if her camera is working. Good.
Okay. And you all can hear me okay? Mr. Clayton, Ms. Armas?
Yes.
Okay. All right, you ready, Joey? Okay. All right, we're on the record in cause number DF 2105-135. Councils, will you please announce for the record?
Justin
Brian
Dale for the
Adamson. Go ahead, Justin. Sorry.
Justin Dale for the AG's office.
Okay.
Brian Adamson for the Move It.
All right, and those who intend to testify, please raise your right hands. Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
I do.
Thank you. Thank you. You may lower your hands. So we're here on a motion for enforcement that was previously filed on May 14th of 2025 by the Ms. Armas. And it's come to the court's attention that there are some agreements and the only issue that the court needs to take up is the contempt portion. Is that correct, counsels?
Yes, ma'am.
Yes.
All right. Okay, if you want to proceed, Attorney Adamson, and read the agreements into the record.
Judge, the agreement is that a judgment will be found for child support arrearage in the amount of $69,612.82. A judgment would be entered for medical arrears in the amount of $24,140.96. The ongoing child support in the amount of $1,237 would continue. The ongoing medical support of $250 would continue. That in addition to those two payments, a payment towards the arrearage on child support in the amount of $250 a month would be added. And in the amount of $150 a month for medical support would be added, making a total of just under $2,000 per month.
Okay. Does that conclude the agreement, council?
Yes, Judge, the judgment as of dates is November 30th, 2025 for both amounts.
All right. And regarding the contempt, the court will take up testimony on that. Well, before we do that, what is the issue with contempt specifically?
I think the issue is simply no one wants to be held in contempt, Judge. I don't know that there is a defense to it. I'll let Mr. Castillo address that. We have agreed to forego any jail time for now, pending future obedience to the court orders.
Okay. All right, so, well, Mr. Castillo, jail time is not, let me make sure this is, okay, Mr. Castillo, jail time is not the only option for contempt. You understand that, right?
Yes, I think I do, yes.
Okay, so you know, if you're held in contempt, you could also be placed on community supervision, probation.
I did not know that, but now I do, yes.
Yes, so even if I were to find you in contempt, that doesn't necessarily mean that I have to place you in jail.
Okay.
Okay, and I'm not trying to change your mind. I just want to make sure you understand that. And so I'm going to ask, does that change your mind about wanting to proceed with having a hearing on contempt, if that's an option for you?
If that's an option, I would not like to continue.
Okay, so what I can do is, Attorney Adamson, if you would have a conversation with Mr. Castillo, I can that'll give me an opportunity to bring the community supervision community supervision officer into the courtroom, and that way he can get their contact information.
Happy to do that, Judge.
Okay, so let me place you all back in a waiting room. Excuse me, waiting room, breakout room. Will it let you join that room again?
Not me.
There's been no notification thus far.
Okay.
Oh, I'm sorry, Judge. There is a link down at the bottom to join it. Should I just click that?
Yes, click that. State. It looks like he's already gone over there. Just click that, Mr. Castillo.
I don't see the link, so.
Are you on your phone?
Yes.
If you tap the screen, do you see where it says breakout rooms?
It says more. No. Do I push? Okay, I got it. Yeah.
There you go. Okay, on the Legy case.
Present, Your Honor.
All right. Let me pull up that.
Morning, Your Honor.
Good morning. How's everyone?
Well,
Okay, so I'm pulling up all right, the first thing that popped up was a motion for continuance.
Excuse me?
I see a motion for continuance that was filed on last week, the 26th.
that was by me, Your Honor. I'm pro se. I was having difficulty. Our daughter has overnight nurses and caregiver help during the day for me. And due to the weather, the nurses couldn't make it in. But the continuance we're fine. I'm fine. Everything's fine.
Okay, thank you. Thank you. Sir, I see that you filed the motion for contempt December 22nd of 2025. Is that correct?
Yes, ma'am. Yes, Your Honor.
All right, and then you filed a supplemental motion on Christmas Eve.
I believe so. This is mainly, it's a motion to enforce and a motion for contempt.
Okay, all right. So that's the one you're proceeding with today.
Yes, and I would just say, first of all, Your Honor, I do this not, I feel bad that I have to do this. I do not want Angela thrown in jail. That is not what I'm seeking here today.
Okay,
I'm seeking enforcement, and I think you'll understand once I present my argument.
okay. So I'll give you the same courtesy as I've given everyone else. Have you all had an opportunity to speak about reaching an agreement?
There's not going to be an agreement with her. We don't communicate well. I've asked, when you hear my argument, you'll understand I've asked numerous times for her to comply with the court order, and she's ignored it.
Okay, let me see. Let me grab the underlying order. Okay, the underlying order was entered March 14th of 2025, correct?
Yes, Your Honor, and the MSA was entered, signed and executed on January 8th of
Okay,
last year.
all right.
And may I, when I proceed, may I share?
Oh, yes, both of you can share your screens as needed. Let me look at the exhibits.
I essentially plan on arguing off the exhibits, Your Honor.
Okay, so I do have your exhibits, Mr. Leegee, or, oh, you just sent, oh, it's one file. So I see, okay. I see 1 through 11.
Yes, Your Honor.
Okay. And then Miss Leegee, I see. Let me see. I see exhibit 31. Let me see what else.
That was supplemented the day of the exhibit exchange conference. But there should be exhibits 1 through 30. I merged them all together.
Okay. I'm guessing it's this one big email. Let me see. I mean, excuse me. Ooh.
And then I had numbered them.
My hearing is starting to tell the client it'll be 30 more minutes, okay?
Also, Judge, can I bring to your attention less than 48 hours of this hearing this morning? Mr. Leegee sent me a intimidating email. Just remember, I tried to be nice. What will happen to you on Monday? ... Well, you brought this on yourself. It won't be pretty.
I object, Your Honor.
And
That's
it has
not part of the
caused-
exhibits that we have entered
It has
into.
caused undue stress.
Hold on. You all cannot speak over each other. And you won't speak over each other because I want you all to have a clean record, okay?
Thank you.
We're not even on the record yet, so let me just make sure I have all of your exhibits. I want to make sure I have all of them before I go on the record and admit them. And one through 31 were pre-admitted.
Yes, Your Honor.
So if you click on where it says R's exhibits, she put everything in that one email.
I had submitted them previously, each one by itself.
Okay.
And I got a email stating I need to resubmit because I typed in the wrong cause number. And then I also thought, well, maybe I need to merge them all as one big. And then if you can see on the bottom, I had numbered so you can follow the pages. Exhibit 1 starts with 1, Exhibit 31 ends with page, I think 58, if I'm correct.
Okay, so the way you did it the first time was actually correct.
Oh, was it? Okay.
My
My
court
fault.
reporter, when she submits this to the Court of Appeals, if you all were to request the transcripts, the way that she uploads it, it has to be individual.
Oh.
Would you mind resending her those exhibits? I have yours, Mr. Leegee. Let's see something.
And Your Honor, I am here to respond to petitioner's motion for contempt. I had also filed a counter motion
Okay,
and I apparently filed it wrong, so I need to refile that so I can request a hearing later on.
okay, are you referring to the response that you filed on January 20th?
Yes, I filed the response, and in that response, I also filed two more, a contempt of court and counter motion
Okay,
for enforcement, communication restrictions, and enforce the 500-foot distance around my place of business.
okay, I see that.
Which were not properly noticed, and we're not here on those today, Your Honor.
Correct. This- Joy, do you want to get the exhibits first?
Ones that Jean said, I mean, and then I have some that were sent on January 1st and 2nd.
Could you forward that to me? Are they 1 through 30?
No, they're not. It's like 1 through 10.
Yes, Miss Leachy, if you would just resend. Her name is on the screen, Joey Rivera. So it's Joey, period, Rivera at dallascounty.org. That's the email address they should go to.
It's on the screen. Hold on.
Yes, can you see Joey Rivera on the screen? You know what? I'll make it easier. I'll put her email address in the chat.
Okay, thank you.
You're welcome. Okay, can you see that email address?
Yes.
All right. So you all give me a minute. The other case is back. Attorney Adamson, Mr. Castillo, Attorney Dale, Ms. Armas.
Yes.
Okay, so you all, did you all come to an agreement on the community supervision portion?
Yes, ma'am.
All right. So Joey, could you send a message? Joseph? Yeah. All right. Yeah, because DF 21-05135. And let me know when you're ready so we can go back on the record and put this part as their agreement. Yes. All right, we're back on the record in cause number DF 21-05135. All right, and you all have an additional agreement about the community supervision, is that correct?
Yes, ma'am.
Okay, so in regards to contempt, is the agreement to find that Mr. Castillo is in contempt of court?
Yes, ma'am.
Okay, and what is the remaining agreement?
That there'd be 12 months of the community supervision in lieu, and the sentence would be stayed pending continued payments being made.
All right. Did you all have an opportunity to discuss in the event that payments aren't made and there is a motion to revoke file, what that sentence would look like.
No, ma'am. I assumed it'd be the normal 180, but we did not go into specifics with Ms. Castillo.
Okay, so Mr. Castillo, typically it is 180 days per violation, okay? But Mr. Adamson, if that were to happen, Mr. Castillo, that's not to say that it will happen, okay? As long as you stay on top of doing what you're supposed to do on community supervision, you don't ever have to worry about triggering that portion. But Attorney Addison, are you asking that the for the violation that it's 180 days to run concurrent?
We would have it run concurrently. Yes, Judge.
Okay, so Mr. Castillo, that means that instead of the 180 days per violation, it'll be 180 days in total if your community supervision were to be revoked. Do you understand that?
What does it mean by 180?
180 days. So you'll be placed on community supervision. I'll be with you all in just a minute, okay? You'll be placed on community supervision for the 12-month period. So in that 12-month period, you just have to make your payments on time for child support as well as your medical support. If for any reason you fail to abide by the court order, like your court order to do so, Ms. Armas could file a motion to revoke your community supervision for that 12 months. And then you could potentially be placed in jail at that time, but the jail sentence will not exceed 180 days.
Okay.
Does that make sense?
Yes, it does. Thank you.
Okay. All right. So the community supervision officer, he might be busy. He's not available right now, but Attorney Adamson, when you prepare the order, could you just make sure that you put that statutory language in there for the probation department? What the sentence will be, that the 180 days will run concurrent, and that Mr. Castillo is to report as ordered by the community supervision department?
Yes, ma'am.
Okay. All right. Is there anything else for the or did you all discuss attorney's fees at all?
No, ma'am, we didn't, and I should have.
Okay. Yes, you all should discuss attorney's fees. Because Mr. Castillo, as a part of contempt. Now, granted, you all can discuss it and decide not to do it right now, Attorney Adamson. And you can waive that right now. Well, not waive it, excuse me. You can reserve it to bring up potentially at a motion to revoke if you choose to do that.
I would need to talk to my client instead of doing that, Judge. Can we jump into the breakout room one more time? I apologize.
No problem. Just you and your client?
Yes, ma'am.
Okay. You have exhibit yet? Legie?
I am trying to find them, how I get to the individual ones that I submitted.
They were sent, yeah, no, it definitely wasn't 30 though.
Okay.
Yeah, it was sent. I see where it was rejected, and I was hoping I could just click on the.
You might have to do multiple emails. So if you want to do like 10 at a time, or maybe even less than 10 at a time, to send multiple emails, that works too. I just want to make sure I have all of them before I go on the record and stipulate to them.
Right, right. I am computer illiterate, so let me.
All right, and I'll be right back with you all. Thornhill.
Yeah.
You all may come up. No. Y'all come up here. Come up here. Bring your stuff. Do y'all have any good news for me? Not even a little? Not one thing? Okay. All right.
I'm not gonna be insulted because you think it's your turn to speak, now you're gonna
See
say
how,
insulted.
see how I keep getting cut off. You see the attitude, penalty.
So let me ask this. How do y'all talk to each other in front of your boys? Y'all don't talk at all?
About 4 or 5 words off.
Mm-hmm. So let me ask you this question, because like I told you, you all do not have a case pending right now in front of me. All right? I remember you saying that. Would you,
Does not sacrifice anything, as you said, she would have to be on something. She doesn't want me to do what she's already left me to do with the boys. She's left the boys with 3 times in totality. But it's her that wants to keep the control for. She said, because she doesn't trust me, I try to get her to articulate exactly what it is, but she cannot. She'll bring up.
hold on, let him speak. Keep talking, keep talking. Hold on 1 second, 1 second.
It's just an example. Anything getting hit with, she gotta come in because she understands that she doesn't have ground.
Okay, stop right there, stop right there. Go ahead.
It's just, it's not true. I just don't listen to several things that he's done. It's like
When you say trust him, are you, what, y'all have to be specific because I wasn't in the room talking to y'all. Didn't I let, hold on. I let you speak. Right, because I don't want either of you to keep talking. I have to hear both. I don't have to hear all of your side, but I just needed to hear one little piece about how you felt about what she wasn't doing. And you said
Speak more because this is my case that I brought.
you don't have a case. We had this, hold on, you do not have a case. What you filed, I said it was improper. And this, what I'm doing, I do not have to do it. I just want to make sure both of you understand that. But because you're here, I'm doing it. And I'm doing it because I care about Cairo and Egypt. So when you say that let me ask this. What did he ask you for?
custodial.
For the kids to live with him primarily?
Oh, in this room?
No,
Overall, yes.
that's what he asked for. What is your opposition to that?
I don't want that. I want time with my kids. I want the joint custody, and I don't trust.
Okay, so hold on. Let me walk, because y'all both say a lot, and I gotta make sure I say something at each point. Joint custody won't change. You both will be joint managing conservators. Okay, that's by law. Unless there is an issue that I find that it is not in their best interest, and to get sole custody, I mean, it's a high burden. You all are joint managing conservators right now.
That's a misunderstanding.
Okay, that's not changing.
It could still be 50-50, but I get to choose what school they go to.
Okay, so you listen, what he just said, y'all are joint managing conservators. That's not going to change. Right now, you're the primary parent that determines the primary residence. Is that what you're asking for? Just yes or no? Okay. And you said your opposition to that, right? Does your opposition have anything to do with him potentially harming the kids? That's a yes or no? Okay, when I say, let me be more specific when I say harm, okay? Because both of y'all are parents. And your opinions of how you all parent I'm not asking you to do anything perfect. What I'm saying is harm. Do you think he would potentially let your kids be placed in danger? Okay. Do you believe that he does not care about their education? What school do they currently go to? What school do you want them to go to? Nope. What school do you want them to go to? Okay,
It was the incident that happened across the street from DeSoto. And, you know, I'm
so what school?
a school with more diverse culture where it can
What school?
Oh, it could be a Grapevine, Propel, Carrollton,
Where do you live?
so
Where do you live? Y'all live far from each other. Okay, so that's gonna be where the rubber meets the road first. Now, aside from who gets to determine their primary residence, wherever they live, that's where they have to go to school. You have to be able to tell her what school you want to put them in. This is where the co-parenting has to come in, right? She would need to know, just like I would need to know. You couldn't come in here and say, Judge, I want them in a different school outside of faith. But when I ask you what school, you don't have that to tell me. You have to be ready to tell me, hear me out. You have to be ready to tell me, Judge, these are the schools that I'm looking at least 3, so you can give them to her. And these are the reasons why I want them in these schools versus faith. Okay? So before you all can even talk about that, before she can even agree to that, before you can even present it to her, you have to have some already lined out to say why these particular schools would be better. No, I just asked you which schools.
it was it's very
I
recent.
got that. But listen to what you're saying though. You,
Carrollton, Grapevine,
what schools, not the location, which schools? I need the names.
Either.
And that's, hold on. You can't move. So let me ask this question. Those schools in those areas, how would they go if neither one of you lived there?
just specifically to have them in a better school district because
Okay, so when are you going to move?
it's gonna be, because the only reason I'm at where I'm at is because the situation is as it is. But when I get custodial, then I'll still talk about like, hey, this is the school I'm looking at because of the collegiate and scholastic.
I would recommend you do that first. Because remember, you just said that you were going to file a modification. When you file a modification, it's a material and substantial change that has occurred since the order was entered. We can't do anything in law based on something that may happen in the future. It has to be here today. And as of today, neither one of you live where you just mentioned you want these kids to go to school. Neither one of you do. There hasn't been any research done for a specific school. Now, you may talk about districts, right? But the specific school, I would already need to know that. I would need to know everything about these boys. Like, do they have a learning disability? Do they have testing anxiety? Like, what about this particular school or these particular schools that is going to be better for these boys over faith? Because even though you may want something and you may want something, because you all put me in your business, if I don't feel that needs to change, it will stay the same. And if I believe nothing needs to change, it needs to stay the same, you two got to figure out a way to make it work. Ask me a question without accusing him of anything. Okay, go ahead. There is nothing new per se. I don't, nothing is here right now. But what I would encourage you all to do, obviously, that attempt today didn't work to get you all to mediate, which is fine because I just said something very key to the both of you. Yes. So before you can even come to court, the law says material and substantial change since the order was entered.
The original order.
The original order. If that threshold has not been met, by law, I can't do anything that you want me to do. So that's why I am encouraging you before you go there, put some things in place. Because once things are put in place, conversations can be had, but you can't put the cart before the horse.
I don't want to be insulted.
You're not going to insult. You're not going to talk. You're not going to do something. You're not going to do something. Like I could sit here all day and tell you all what you're not going to do. But you all are grown. Y'all have to figure this out. You don't need to come see. I know y'all want to come see me. I know y'all want to come see me. You know, she a cool judge. She listen. And I'm, if I know, I get it, right? But at the end of the day, I don't want y'all to come down here and see me. Because if you come down here and see me, it's a serious matter. And I have to do what the law says that I can do. Although I have discretion, I cannot violate the law. So this is something else I would ask you all to do. There is no case pending right now for a modification. Nothing. I can't order you all to do anything. But if you all would agree to set up mediation, I can give you the name of a mediator or a couple of names of mediators that I believe that's going to pull you two together at some point because they don't play. Are you open to mediation? What did I ask? Let me make sure she answered it. What is it that you don't trust about giving him the right to designate the boys' school? Without accusing him of anything. I'm asking a very specific question. Don't accuse him of nothing. Tell me, what is the hang up with you not giving him the right to designate the school that these boys go to?
Of everyone.
But everybody doesn't matter. Remember, Cairo and Egypt. So when in regards to them, what is your hang up with giving him the right to designate their schools?
Because I don't know what school he wants.
And that's fair. No, she did answer it. It's just not what you want to hear. That's fair because I said that. Okay, DeSoto. You have an issue with DeSoto. And that's fair too. Both of you make very fair points.
But as she said before, stuff that happens at all. It was the school they go at now. Our oldest son was in a big fight that I have camera at the McDonald's, and it's very dangerous.
He was trying to DeSoto.
Okay, so look. And I went to Carter. And here's the deal. I homeschool this one. I homeschool. So trust me, both of you have very valid concerns. I get it. So
When it comes to
hold on. I don't want us to move backwards. She said yes. Are you open to mediation? Okay. Can y'all do me a favor and look at your calendars and see how soon you can do a mediation? Okay.
he still didn't answer what she doesn't trust about. She just had an issue with the school.
Well, I think she did answer. She didn't have anything about you, their education. We got it. No. I mean, in terms of when I asked that question, I was saying, do you not trust that he would do what's in their best interest in regards to their education? Again, hold on. Again, let me be even more specific. Do you believe he won't take them to school? Okay, do you believe that if there's a concern with the school, he's not gonna go up there and do what he needs to do? Okay, hold on, hold on, hold on, hold on, hold on. Okay. Do y'all want my intervention or not? Okay, then y'all gonna have to stop talking. Listen, hold on. Hold on, hold on. Oh my gosh. Oh my gosh. The boys, the boys, the boys, the boys. Mr. Thornhill, Miss Thorn, are you still Thornhill? Yes. Miss Thornhill, stop, stop. The boys. We're talking about the boys. At the end of the day, she does not have a problem in thinking that you're not going to do what's in the best interest to these boys as it relates to their education. That in itself, now, like I said, parenting may be an issue. But at the end of the day, are these boys getting to school? Are these boys getting what they need at school? Are they flunking? If they are flunking, do you think that he won't do what he needs to do to make sure that the boys get what they need? If they got to go to tutoring, whatever the case may be. I'm not hearing anything like that. So let me just say, because I'm not hearing anything like that already, I have to believe that he will do the right thing. Hold on, hold on. I didn't ask you to speak. I'm just saying. Again, let me reiterate just in case y'all need to hear it again. You're both great parents. You are great parents. You are great parents. You are great parents. I will say that until I'm blue in the face. You are great parents. Stop tearing each other down. Don't do that. And definitely don't do it in front of me because hold on, I don't need either one of you to speak right now. Let me just get some dates. Let me get some dates. Hold on one. $15, $16.
27, 28, 20. 9:30.
The only way that you all are going to be able to be better parents is if you start fresh today. We're starting. Okay. Yeah. Make sure the boys are okay. Um, Hold on. I can't talk to you without her. So hold on.
Yeah. Give me 30 minutes.
Everything okay?
He hurt his neck. He said he flipped wrong handcuff.
Okay, so y'all both about to take him? Oh, that wasn't my question. Stop. Stop. Both of y'all are doing that. It is not, hold on, but that's the thing. Y'all do not have to do that. I don't know how much I'm going to have every time. I don't know how I'm going to reiterate that. You all cannot throw daggers at each other. That pettiness has to be let go, and you both have done it in here. That is not, yes, you have. What did you say about that tax return? Stop. No, stop. I don't want to hear it. No, no. What I'm saying is that you said it. It's petty. I don't care. I do not care. I do not care. At the end of the day, you all are not going to be able to be good parents if y'all can't even stop doing that. So if he need to go to the doctor, both of y'all go to the doctor. If something wrong with him, go now. Matter of fact, I'm about to release you so y'all can go take care of your son. Go ahead and send the email. I don't need it. I don't need it. I don't need, how about I don't want it? I don't want it. Which baby was that? Egypt is hurt. Egypt needs to go to see a doctor. He probably needs to go to a physical therapist. Both of you need to go take care of your kid. Y'all are dismissed. Go handle that with Egypt. And make sure y'all tell him that I hope he's okay. And you gotta go because I can't talk to you without her. I'm not hearing nothing else. Y'all need to go to mediation. Y'all have a good day. Good morning. Okay, so.
Hey, how are you? Good.
Hey, Tony, Castillo Adamson.
Yes.
We're here, Judge.
All right, so were you all able to have some discussion?
Yes, ma'am.
All right, so what did you all come to?
We decided, Judge, that we would do the contempt with a 1-year supervision. And like everything we said earlier, that's the only addition we have.
Okay.
Oh, sorry. We were on attorney's fees. I'm sorry. It's been so long. I forgot. No, the attorney's fees, we're going to reserve if there's a violation.
Okay, so we're back on the record. So we took a break for you all to discuss the attorney's fees as it relates to the contempt. And counsel, you can go ahead and state what you all's agreement was.
So the agreement is that we're going to reserve attorney's fees, any judgment on that pending any violation in the future.
Perfect. Thank you all. And thank you all for your patience and thank you all for working this out too, okay? Attorney Adamson, how long do you need to prepare the order?
7 days is fine, Judge.
All right, so let me put you all on a, I'm going to put you all on a dismissal docket for the order entry. And then I'm also going to do a report back because Mr. Castillo, I want to check in and see how everything is going, okay?
Okay.
All right, so I'll do 6 months. So pull out you all's calendar. So that'll put us around what, August?
Yes, ma'am.
Okay, so right now the dismissal docket, the earliest I have is February 13th, that's next Friday. And Mr. Castillo, the way that works, Mr. Attorney Adams is going to prepare an order and you'll have an opportunity to review the order after he sends it to you. You can agree, if everything looks good, you can agree to it, or you don't have to agree, right? And if you choose not to agree, you all will show up on that day and you'll state whatever your disagreement is, and the judge will more than likely sign the order. If you do agree, you can sign the order or you don't have to sign it because the only signature on it that matters is mine. And if that were to happen, you don't have to worry about appearing on that day, okay?
Okay.
All right, so let me go ahead and add this to the docket. Give me a minute. All right, so I have added you all to the entry / dismissal docket for February 13th, 2026 at 9:30 a.m. That'll be before Judge Lee. Let me give you this Zoom code. Let me know when you all are ready.
Ready?
It's 961-1106-4392.
Got it.
All right. Any questions before we are done?
Did you want to set the 6-month review date as well, Judge?
Thank you. Thank you. I forgot that fast. So August, are there any dates that you all are not available in August?
No, ma'am.
No.
All right. So first available I have is the week. Do you know when advance? Do you know if advance is going to be the 3rd or the 10th?
I don't know. I haven't been advanced in a while.
Let's do the 3rd. If you all are available, it'll be via Zoom.
I could do that.
All right.
I can as well.
Yeah.
Yeah, August 10th to the 13th, by the way, Judge.
Thank you. Mr. Castillo, can you do August 3rd?
Yes, I can.
And that'll be in front of me via Zoom. So let me go ahead and swear you in. Raise your right hand. Well, state your name.
Clayton Castillo.
All right. I am swearing you in to reappear on Monday, August 3rd, 2026 at 9 a.m. via Zoom, the same Zoom code you used today, 688-044-0164. Your failure to appear at their report back date could result in a KPs being issued for your arrest. Do you understand those instructions?
I understand.
Do you have any questions about those instructions?
No.
Okay, you may lower your hand. Is there anything else for the record?
No, ma'am.
Okay, Joey, do you have Shelton's email address? I can at least give it to Mr. Castillo right now. Mr. Castillo, let me go ahead and give you, and Miss Attorney Adamson, you can have it too, since we're on here. Is it the same Shelton.Brown? I believe it's Shelton, SHELT as in Tom, ON as in Nancy, .Brown, BROWN @dallascounty.org.
Got it.
All right. All right. Thank you all again, and we'll see you back in August.
Thank you.
Judge.
You're welcome. Have a good day.
You as well.
Thank you. All right, Leachy, I just saw your message, Miss Leachy, in the chat. You said you sent it by zip.
Ms. Leachy, you're on mute.
Oh, you're on mute, Miss Leachy. Oops, sorry.
I'm sorry, Judge. I could not find the ones, I couldn't find where I had individually saved those anymore. So I sent an older zip version because when I e-filed and they got resent back to me because I did something wrong, I looked at all of them. I thought, oh, well, that's not numbered correctly. Oh, we don't need this. And I added like a footer. So it's different what I sent Joy. That's what I'm going to have to go back and figure out where that merges. I am computer technologically not.
Mr. Leachy, would you possibly have her exhibits and email that you could forward to the court?
Your Honor, may I show you what I have?
Yes, please.
I have her exhibits here we go. They're all combined.
Yeah.
1 through 30 or 31. But they're mainly for her motion for contempt against me, as she stated earlier before we went on the record, because when she started crying. I don't think any of them apply towards my motions to enforce. That's why I had no objections to them.
That is not true.
But I can send you this, what I have right here.
Um, that would be great. Could you forward that to Joey in that email address that I put in the chat, please? And Ms.
Yes.
Lee, you're going to have to tell us which exhibits apply to his case today, because anything that you file that's not set before me today, I can't entertain it anyway.
Correct. And I do need to, I wasn't sure how to file. I filed everything as notices, so I do have a contempt on his end and enforcement also, but I was told by Judge Lee I need to file those correctly.
Yes, and like I said, they won't be entertained today. So I just need to know, Ms. Felici is going to send me all of those exhibits, but I'm only entertaining the ones that will pertain to today's hearing. So
Okay.
you're going to point them out for me.
Oh, okay. Okay. Point them out right now?
Well, once I get them,
Okay.
so I can follow them with you. Attorney
I
Chavez,
just sent them.
good day.
Judge,
You're welcome.
And
Good
I
to
do have an exhibit page attached to them, so it'll be easier to follow.
Okay. Thank you.
But can I say something, Judge?
You may ask a question. I'm not entertaining any testimony just yet for evidence or anything like that, because we're not on the record. So if you have a question, I can entertain that.
I have a question. Due to the recent medical emergency our daughter had Thursday night, where paramedics responded to the home, I have a question about the decree clarification and temporary relief, as I need the mobility van that she uses because she's wheelchair bound. I need temporary authorization allowing the S&T 142 trust to pay for the insurance coverage.
This is what my case is all
have
about,
not,
Your Honor.
they
She's
have
arguing her case.
Hold on, you cannot talk over each other. I can only listen to one person at a time.
The S&T Special Needs Trust did say they were willing to pay the insurance if both parents agreed. I agree, and Scott disagrees, and so it's a parental disagreement, and that's what they're waiting for. And due to the paramedics coming and me being unable to transport her to the hospital, I'm asking for temporary authorization until the guardianship proceedings are decided. It has been quite stressful. She has 9 specialists, and the inability to pick her up from school early if she's sick, the inability to take her to her cheerleading events that she has missed since December 11th when petitioner canceled the insurance. Thursday was just an underscore.
So what is it that you're needing? What's your exact question?
The exact question for you is to temporary relief authorizing that the Special Needs 142 Trust will pay for the insurance until the guardianship is considered. They are in limbo because of the divorce decree, because the unambiguity of it all. And but they did state they will pay for the van insurance as long as both parents agree. I agree, and petitioner disagrees.
That's what we're here about, Your Honor.
And
She's arguing her case.
it's a lot.
Okay, so does this have something to do with what you filed that you want me to entertain that's not set for today?
You talking to me, Your Honor, or her?
This is the contempt that petitioner, Mr. Leegee, has filed.
Your Honor, if I may proceed.
Yes, because I don't remember his okay,
I think you'll understand when I go through the exhibits.
okay, we don't have her exhibits.
My exhibits.
Okay, did you forward me her exhibits?
I did, Your Honor.
Okay,
Now, I don't know if I got kicked back or not. I'm looking right now.
I can forward the,
Your Honor, they did not get kicked back. They've been sent to, maybe I sent the wrong email, JOIE, did I spell that wrong?
yeah, they just came through.
At dallascounty.org.
Yeah, it's Dallas County. It was coming over to Dallas County. That was the delay. She just got them, so she's about to forward them to me.
And
Okay. And if I would ask that the judge instruct the respondent not to speak when it's my turn.
Okay, I'm going to instruct both of you not to
Thank you.
speak unless spoken to. Because if you want a clean record, you have to let the other person speak.
and he's got 11, right?
He has 11, yes. I have his. I have his. I'm just waiting on hers. Are both of you attorneys or are you an attorney, Mr. Leegee?
Your Honor, I've been attorney. I've been licensed since 1997.
Okay, thank you.
And Ms. Leegee is a former court reporter and she is not a lawyer.
Okay,
freelance
okay.
before the children were born. Oh, mine is saying undelivered.
It's fine if his
joyriver@dallas.org.
She has them.
county.org, but he sent
No,
them.
she doesn't have the last number 31.
We have 31.
Okay, okay. And I did submit number 32, the email 48 hours before this hearing, where I,
Is it related to his hearing set for today, or if it's not, I'm not entertaining it?
okay, it's not.
Okay. All right. So I received the email. Thank you, Attorney Leachy. Let me tell you what I have. So we're going to go through each one of these. Exhibit 1, is Exhibit 1 related to today's hearing?
Of hers?
Yes.
Okay. Exhibit 1. I'm looking.
No,
No.
it is stating she's incapacitated and she needs to be in a home.
No, ma'am.
No.
It's a very simple yes or no.
No,
Is Exhibit 1 related to today's hearing?
no, no, ma'am.
Okay. Exhibit 2,
No, ma'am.
3,
No, ma'am.
4,
No, ma'am. Just back
5,
down. Yes,
6,
yes,
7,
yes,
8,
yes,
9,
yes.
10,
Decree clarification trust request. Aye. Thank-
That sounds
Yes.
like,
Okay, no,
okay, 11,
no,
12,
yes, no, no,
It's not.
13,
yes,
well, 13 sounds like the van that you were talking about.
Yes,
Correct.
she said yes.
So it is related.
I think so, but I am not an attorney, so
I think it is.
Okay, 13, 14,
no, that's my later motion.
15,
No,
16,
no,
17,
no,
18,
yes,
19,
no,
20,
no,
21,
no,
22,
no,
23,
no,
24,
no,
25,
no,
26,
no,
27,
yes,
all right, 28,
no,
29,
no,
30,
no,
31.
yes,
All right. So I have 5, 6, 7, 8, 9, 13, 18, 27, and 21.
Can you read those again, Your Honor, slower?
Sure. 5, 6, 7, 8, 9, 13, 18, 27, and 31.
Okay.
All right. Both sides ready to proceed?
Yes, Your Honor.
All right. Ms. Leachy?
yes, Your Honor.
All right. We're on the record in cause number DF 231333. Isaac Leachy versus Angela Leachy. Would you please state your name for the record, Mr. Leachy?
Isaac Scott Legy, petitioner.
All right. And ma'am, would you please state your name?
Angela Lynn Leachy, respondent, pro se.
All right. And we are set here today on a motion for contempt and sanctions filed by Mr. Leachy. Is that correct?
That is correct, Your Honor. I would be willing, because I don't want my ex-wife thrown in jail and having to deal with any of that. If she'd be willing to form the agreement that we're going to drop our contempt motions and just move forward on a motion to enforce and motion for attorney's fees, I'd be willing to make that agreement. You said we haven't talked, but you know, the bottom line is I don't want to have her, if she's found in contempt, which I believe she will be, had to deal with probation and worrying about going to jail, because we do have a disabled daughter that needs her care.
Okay. The contempt is not related to possession and access or child support, correct?
Correct. It has to do with the enforcement and her knowingly violating the court orders.
Okay, so jail time wouldn't be an option anyway. I
Oh,
can't put
good.
her in jail
Good.
for it.
Well, then, if she doesn't want to withdraw them, then I'll move forward.
Okay, so let me swear both of you in. Would you raise your right hands? Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, I did.
All right. So you all are set at 15 minutes aside. This will include any opening statement and closing statement. Should you choose to make one, you can waive both of those as well as any examination. Prior to going on the record, you all had an exhibit conference and there was a stipulation to some exhibits, as well as us having a pre-exhibit conference today for respondents exhibits. So at this time, movements exhibits 1 through 11 are admitted. And respondents exhibits 5, 6, 7, 8, 9, 13, 18, 27, and 21 are all admitted.
31,
And 31, I'm sorry, thank you.
not
And
21.
admitted.
Sorry, Your Honor.
No problem, thank you. I appreciate that. Mr. Leachy, at this time, would you like to make an opening statement?
I would like to make an opening statement, Your Honor, and I'd like to go through my exhibits with you, okay?
Okay, go ahead.
Okay, I'm gonna show you exhibit number 1. Yikes. For all that, I don't have my exhibits. Ew. Ew.
And you
Exhibit number 1 is the divorce decree. It's on page 11 of the decree. It is ordered that Isaac Scott Leach shall have possession of Rebecca, RLM, for up to 2 hours and use of the minivan from 11 a.m. to 1 p.m. Specifically at 11 a.m. to 1 p.m., she shall be surrendered with the wheelchair and van with keys and caregiver at a designated time. Okay? That has not occurred, Your Honor. Ever since the van in and of itself was awarded to Miss Leachy as of the MSA and the decree, I, out of my goodness, my heart, continued to pay for her van insurance through December and informed Miss Leachy that I would no longer be paying for the van's insurance and that she would have to take care of that on her own. At that point in time, she weaponized the van and refused to allow me to use the van, stating that, well, cheerleaders go out in cold weather and wrap up. She essentially, and you'll see later on, she had my daughter wrapped up in 30-degree weather and expected me to walk her around for 2 hours in freezing cold. This is the same special needs daughter that has 9 different doctors and had the paramedics come on Thursday. This is the same special needs daughter who doesn't walk, talk, or feed herself and has a G button to feed herself, which, by the way, Miss Leachy doesn't have to buy her groceries. And she wanted me to walk her around the neighborhood as opposed to letting me have access to the van as the court has ordered so I could take her to North Park Mall in a controlled environment. Then she has also violated the court order on page 44 of the decree. And I want to just make a quick statement that this decree, this agreed divorce decree, was prepared for by 2 lawyers who have a history. Larry Friedman has been practicing law since Methuselah. And I know Larry very well. Larry Friedman is her lawyer, and Eric Friedman was working with Larry. Now, Mary McKnight has retired, but Lisa McKnight has taken over. Between Larry and Mary and Lisa and Eric, there's over 100 years 100 years of divorce lawyering between them. They entered into an agreement on page 44 that Angela will, by February 21st of 2025, apply for Medicare for Rebecca and apply for Social Security income on page 45. By February 21st of 2025. As of today, on February 2nd of 2026, Angela has not applied for Social Security income for our daughter. Upon speaking with Melinda, the special needs trustee, the 142 Special Needs Trust, she stated that since no application has been made, Rebecca has lost that income. If she would have applied on February 21st of 2025, and that had been rejected and reapplied and rejected, at the point in time it would finally been accepted, they could have retroactively given that money back to our daughter. But our daughter has lost a year of Social Security income, which should be deposited into the Special Needs Trust. So for these reasons, the weaponization of the van, not filing for Medicare and not filing for Social Security income is why I'm here. I waited almost a year, Your Honor, trying to get Angela to do these things. And there's a reason why she didn't. Here's exhibit number 2. This is an application that you can apply for Social Security income without having a guardianship in place.
That is not SSI.
Your Honor?
An SSA.
Your
Ma'am,
Honor?
I muted you. Hold on one second, Mr. Leachy. Ma'am, you are out of order. You cannot just blurt out and speak. It is his opening statement or it's his examination of himself. I will not allow him to do that, and I'm not going to allow you to do it. Every time you do it, you will be muted. If you continue to do it, I will remove you from this hearing. Do you understand? Okay. You may continue, Mr. Leachy.
So as I stated earlier, between Larry Friedman and Lisa McKnight, and they entered into this agreement, and Your Honor, I know that you know this, you can apply for Social Security income without a guardianship, okay? Now, I understand maybe Medicare would be declined or denied until she's 20, but you have to start the application process so she can get in line for a group home. Exhibit number 3 is the MSA, and the MSA on page 7 of 12, it states here, Angela Legge agrees to refrain from, and Angela Legge shall not make or submit requests to the Frost Bank trustee of the Chapter 142 Special Needs Trust for the underlying purposes of paying Angela Legge's own monthly living expenses, to include, but not to be limited to, requests or submissions for money to pay for her own mortgage, car payment, insurance payments of any kind, utilities, personal health care, and medical expenses. Okay? Example number 5. On October 4th, I sent an email to Eric Friedman because Angela Legge refused me access on October 4th of my Saturday visitation with Rebecca. Why? She refused because she was, quote, I'm just too busy. Okay? And then I stated again, she still had to apply for Social Security and Medicare. The reasoning why was she had just moved into her condominium and she had her family there and didn't want me to be there around her family. So she just decides on her own volition that the court order doesn't mean anything to her. This is exhibit number 5. This is to the trustee. I cannot afford to pay the van insurance, nor can I afford to rely on third-party transportation. Without access to the van, I'm unable to reliably transport Rebecca to appointments, therapies, early pickup, etc. That is her asking for the van. And later it says the committee's decided that Angela can pay the van, Scott can pay for the policy, the trust can pay if both parties agree, or the owner, Angela, can sell the van. Okay? I did make an offer to pay for 50% of it, but she refused that. Exhibit number 6. Oh God, this share thing, I'm gonna have to. Exhibit 6. This is an Angela email to the trustee. I do agree that the trust should pay the van insurance. It also states that Nurse Joy informed me that Medicaid provides transportations. It's clear that our daughter's on Medicaid. Exhibit number 7. I sent her an email on January 16th of this year. I will be at your house at 11 a.m. for my court order visitation. The weather's expected to be 42 degrees and possibly raining. Will you allow me access to the van in accordance with the MSA and divorce decree? Her response was, I will continue to comply with the final divorce decree and with all applicable safety and insurance requirements regarding Becca's transportation. Your Honor, she did not have allow me access to the van. Exhibit number, sorry, I have to do this to get to the exhibit. Exhibit number 8, Special Needs Trust. Historically, we have never paid for car insurance on a van from the 142 Special Needs Trust. Exhibit number 9. Here's a picture, freezing cold, Your Honor, of my daughter wrapped up with the caregiver and no van. Now, do you see the ramps right here, Your Honor? There's a ramp. She lives in a condominium that has ramps going all the way down a hill in her condominium. And just to say, as part of her motion for contempt of the 500-foot rule, when I go visit my daughter, I have to be within 500 feet. Okay, I'm going to address the issue of when it's not Saturday between 11 and 1 in just a moment when I asked her for testimony. Text message. This is a text message on January 2nd from the respondent. High school football weather is cool and cheerleaders still cheer on sidelines with long skirts and sleeves and leggings. And I said, thank you for the admission. Your Honor, it's clear that the respondent, who claims to care about our daughter's health and well-being, doesn't seem to care about her health and well-being when it's time for me to have access to my daughter. You're going to learn through this when I question her. I have never missed my 11 to 2 o'clock ever. We were working together and scheduling, but I've never missed my opportunities to spend my 2 hours with Rebecca. Rain, sleet, or snow, as long as I have the van, I can take her to North Park Mall, and she and the caregiver and I, we have a good little time. Okay? But she has weaponized the van. I want to go over one of her exhibits as well, Your Honor, that I think is important. Okay, come on. Okay. Here on exhibit number 6, she had, after the motions were filed, Your Honor, She then calls Social Security on January 26th, about a week ago, to set up an appointment to apply for Social Security income. All right? That's what it took. And the reason why I say she only did it because I filed the motion is because when Rebecca had what's going on here? One of these exhibits, I think it's 11. No, I think it's up here more. One of the exhibits now, I would ask it to be admitted, but she stated right here, there was a settlement where Rebecca received a sum of money. I can't talk about it because there's an NDA on the settlement amount, wherein she asked the 298th court to give her $10,000 of Rebecca's settlement money for the purchase of her new house. And she refused to agree as next of friend to the settlement unless she got this money. This is what I'm saying. It's a money grab. Your Honor, I pay $1,840 a month in child support. And if you look at her motions for contempt, I can assure you I have paid every payment timely or well before the beginning of each month. $1,840. Our daughter doesn't eat. She doesn't eat food. She's fed with the tube. She gets liquid shakes that are sent to us by the health insurance or Medicaid. And the respondent is unwilling to pay $150 of that money to get the van insured. Instead, she's using the trust to pay for houses, to pay for the van insurance. It's a money grab, Your Honor. And here's the final argument I'm going to make before I put Ms. Leegee on the stand. It's very upsetting to me that I even have to do this. But the reason why she hasn't applied for Social Security is obvious. The reason is she knows if once she applies for Social Security and Medicare, she will then get on a list. And when Rebecca is 20, if she had done this when she was 18, Rebecca would be placed in a group home by the time she's 20. Okay? Because at 20 years old, she will be approved for Medicare because of her disabilities. She would receive Social Security income from the date of her 18th birthday till she passes. And that would go to the Special Needs Trust, which since Ms. Leegee won't be receiving that money, she's not motivated to apply for it. This is all a money grab. She is concerned that when Rebecca is 20, she'll be placed in a group home and she won't receive her $1,840 from me a month. Now, I'm not worried about the $1,840, but that is the reasoning why she's not doing these things, Your Honor. Okay? Now, at this point in time, unless you want me to testify to my attorney's fees, which I think you don't need that, I can do that later. I'd like to put Ms. Leegee on the stand.
Okay, you may proceed. And counsel, you have 3 minutes left.
I understand. Is it
Oh,
true?
wait a minute. Hold on. Before you do that, Ms. Leegee.
She's muted.
Okay. Would you like to make an opening statement?
Yes, ma'am.
Okay, you may proceed.
I'm here to respond to his motions for contempt. Not to talk about my counter motion, but my counter motion is a contempt of him not giving me.
We're not going into that. You're responding only. What is your evidence going to show in the exhibits that I admitted in response to his motion?
I did not refuse to comply with the court. I was legally unable to apply for SSI without guardianship. I declined to give him an uninsured transportation vehicle for safety reasons and Texas law. We're not going to violate Texas law. I did not deny him visitation. There is an exhibit, I'm not sure which number, where the SNT 142 Trust did list interim transportation for Rebecca. I thought Scott would use that interim transportation, pick her up, take her to the mall, and they can drop her back off. I've used it one time to take her to an immediate doctor's appointment. And so I have never denied him visitation. I denied him an uninsured vehicle that violates Texas law. He is an insurance, a personal injury car wreck attorney. He knows that he cannot drive a vehicle that is uninsured. I was protecting my daughter, the caregiver, him, and the SNT Trust, because if there was going to be a car wreck and an adaptive van with no insurance, everybody could have been sued, even this home that she lives in. As for SSI, I did the application online. At the very bottom of one of the pages, it stated, if you're filling this out for someone else, you need to prove legal guardianship, power of attorney, representative. I've had none of those. At the time I started filling this out, our daughter was already an adult, and Social Security advised me that the application could not proceed while adult guardianship was pending. I had already applied for guardianship. I've gotten the certificate from Texas. I took the classes. I did the FBI prints. Mr. Leegee contested in May of last year. The form that petitioner exhibit 2 SSA 788 is not an SSI application and would not have satisfied the decree. It is a representative payee evaluation form used only to decide who controls benefits, not eligibility or payment. That form is usually requested after guardianship has been obtained. The phone call I made, the appointment I made in December, the appointment was January 26th. This was so I could talk to someone in person. I was supposed to bring, and I had it ready, all the medications Becca's on, which is about 10 or 11, the doctor who submits it or prescribes them, the my bank accounts, all the money she has. She has an SNT 142 trust account at Frost Bank. She also has a Rebecca Marie Leegee trust where Scott Leegee is the beneficiary and trustee at Frost Bank. I had all that information ready. As soon as I spoke, his name was Mr. Rogers, on the phone. He said, because guardianship is pending, you cannot fill this out. You cannot submit. You cannot fill out SSI. She is an adult. We will not do this until the guardianship has been decided. He will shelf it for 6 months. Once guardianship is decided, then fill out SSI. This SSA 788 does not pertain to the divorce decree. Also, I did talk to the SNT 142 trust. If you look at Exhibit 31, Article 6, Section G, they did pay for the van in 2014. That van was brand new, and right now it has 23,700 miles on it, indicating it has only been used for her transportation needs. Also, in subsection G of Article 6, it states they will pay for the insurance on that van. Now, when I signed the divorce decree back in May and the MSA of the early last year, I was under the impression, it was my understanding, don't worry about the part in the MSA and the decree about the special needs trust, because they trump a decree. Don't even worry about that. And so I signed this decree thinking that I was it was my understanding that, I apologize, let me pause. It was my understanding that an SNT 142 trust does not take into account a divorce decree, an MSA, because what if the parents are both not making the right decision for the children? They are an independent financial institution that guards Becca's well-being, medical transportation, living, so much more. And so I signed that decree thinking that portion didn't matter. And it is very upsetting. This is not a money grab. And yes, I do agree that I did ask that Becca's hip case that just settled earlier last year, that the father petitioner made $30,000 off this case. I thought we were supposed to split that money, but it didn't happen. I found a home close to where we used to live. It had everything that we needed, that Becca needed, and that I was still able to work from home, flexibility, be with her if I needed, if school needed me to pick her up, all this. And so I requested $10,000 from her settlement, which I thought Mr. Legee should have paid, but I requested 10,000 because I needed 5,000 for earnest money to show the sellers of the townhouse I'm in now that I'm serious. And then I requested another 5,000 for modifications in the home for her wheelchair and the inspection. And it was given to me. Mr. Legee wanted me to pay it back. The judge said no, because this money clearly goes for your daughter. And Attorney Gaines West agreed, and the guardian ad litem agreed that I should not have to pay that back because everything in this home, and I have showed pictures, everything I do for her, everything. And Your Honor, the contempt requires a clear, willful violation. In each issue Mr. Legee, the petitioner, has raised, I acted in good faith. I followed legal guidance. Texas insurance, auto insurance. I did not intentionally disobey. I followed legal guidance on that SSI. I could not go forward filling that out without legal document showing them that I have the right. She is nonverbal, deaf. She does speak. She doesn't speak with words. She speaks with gestures. She speaks with hand over hand. She speaks with smiles. She speaks with groans. She does not speak as a normal, regular person speaks with their mouth verbally, but she does speak. I understand certain moans when she needs me. I understand certain smiles. I understand when she has hand over hand and she puts her hand on on her head that she wants me to scratch her, or her foot, she wants me to massage it. So she does speak, and it angers me that her father does not know this. And I'm not going to get emotional over this, but I do ask temporary relief until guardianship is decided that the S&T can pay for insurance. I cannot afford it. I cannot. I am starting over as a fitness instructor, as a pickleball coach, not making a lot of money right now, but I will. I believe in myself. It's going to happen. I know it. But until then, the trust knows. I told them, when I get on my feet, I will pay for the insurance, but I have to get on my feet. This all started in September. I have not worked since my children were born. I have been fortunate that Mr. Legee is an excellent attorney and has provided me the benefit to be a stay-at-home mom, taking care of both our kids. One twin, Joey, is on the spectrum, high functioning, and I thank Scott that he had the ability so I could stay home and take care of the children and take care of their medical needs. And right now, I am making not enough money to pay for the van insurance. The townhouse cost, the home insurance on the townhouse was almost $10,000 because of the separation of the garage, and it was just a lot. And I had to get the electrical box updated. That was another $2,300. So it is not a money grab. It's never been a money grab for me. I grew up with no money, and then I had money when I married Legee. Now I'm back to no money, which is fine because I will make it, because I've always made it in my life, and I am determined and I am resilient. And for him to say contempt is wrong. I have tried, legally tried, and for these reasons, I just respectfully ask that you deny his petition of contempt. But I do request there has to be some form of different communication. I am constantly getting harassed 3 or 4 times a week through emails by Mr. Leegee. I need the 500-foot rule enforced because this is also my residence and my place of business. And I'm pointing because this garage up here has my Pilates equipment and studio. And it's interfering with when neighbors heard him, the recent incident outside the home trying to pick Becca up, and I refused to give him the van because it was uninsured. Neighbors across the street called the police. The next door neighbor called the police. I don't even know the neighbor across the street. But I probably went more than what I was supposed to, and I apologize. It's a very emotional, but I do request clarification on the decree because it is not a living expense. This van is not a living expense. I have my own car. I pay for my own car. I pay for my own insurance. I pay for everything. This van was specifically bought for Becca by the trust in 2014. It is used for her and her alone. There is no other way for me to get her to doctor's appointments. There is no other way. I can use the Medicaid transportation, but I have to call 5 days in advance. If she is sick today, I can't take her to the doctor because this van is uninsured. I would insure it if I had the extra cash. I don't have it right now. I do not have it right now, but I will have it. I need a little bit more time. I'm starting over 18 years, new career, trying to run my own business, which I've never done. But that's all I have to say.
Does that conclude your opening statement, ma'am?
Yes.
Okay, you have 1 minute left. Attorney Leachy, you may call your first witness.
I call Angela Leegee to the stand.
Okay, go ahead.
All right, I'm going to share with you what AI says about, can a parent of an 18-year-old disabled daughter in Texas apply for Medicare? Yes, a parent can apply for Medicare on behalf of an 18-year-old disabled daughter in Texas. She qualifies through Social Security disability insurance. And I'm sure my daughter will apply with that. Do you agree with what the AI says here about applying for Medicare?
I do not agree because it does
Thank
not
you.
state
Thank
if
you.
guardianship is
I said
pending.
thank you.
Guardianship is
Your Honor, I'd
pending.
like to reclaim my time. Just answer with a yes or a no. You disagree with that, is that correct?
I disagree. It's
Okay.
not a full explanation of the circumstances.
Ma'am, just answer the question, and then when it's your opportunity to speak again, then you can clarify, okay?
Has the petitioner ever come onto your property other than on Saturdays, first, third, and fifth Saturdays at 11 a.m. to harass you in any form or fashion?
I have to look at the date.
Your Honor, I'd ask that the clock would stop while she's playing this look at the date thing.
The question was, has the petitioner ever come onto your property other than to harass you in any form or fashion? It's a yes or no.
Other than to harass me?
Now, the question, let me rephrase the question. It was, has the petitioner ever come on your property other than on a first, third, or fifth Saturday at 11 a.m. for his visitation?
Yes, on a Sunday.
At your 6446 South Point, you're saying, is it your testimony that the petitioner has come onto your property on some day other than a Saturday between 11 and 1? It's your sworn testimony.
I don't want to get caught in dates. What was the day again?
Has your
He didn't give a date. He asked a very specific question.
Right.
Your 6446, is it your testimony that the petitioner has come to your property on any day other than a Saturday between 11 and 1?
Yes.
What day would that have been?
I don't know the date, but it was a Sunday.
Was it for visitation? Because there was a trade-off?
Joey was brought over.
Oh, okay. Joey was brought over at your request to visit your son, correct?
Joey wanted to come over.
Okay,
And Joey has been here before where I've picked him up and he stayed a few hours. We watched movies.
so is it true that Rebecca does not eat food?
That is not true.
Is it true that Rebecca is mainly receives most of her nourishment through a G button and liquid nourishment on a
She
slow
eats
drip?
macaroni and cheese. She eats applesauce. She eats pudding.
My question was, does she primarily get her main nourishment from the G button and a slow drip of her feed?
Majority, yes.
Is it also true that you were arrested for family violence in front of Joey and Rebecca before this divorce happened?
No,
Have you ever been arrested at 16302 Shady Bank while we were married?
no.
You've never been arrested? I didn't say committed a
Expunged.
crime. Have you
It
ever
was
been sent to jail?
expunged. It was expunged.
So you were
We cannot
arrested?
talk about this. No, I was not.
Okay, ma'am, Your Honor, have you ever been arrested, thrown in jail at Lou Sterrick, and then later had the charge dismissed and expunged?
I do not have
Answer
to
the
answer that question.
We'll let the judge decide that.
Was there an objection, counsel?
She's not objecting. She says she's refusing to answer it.
No, I'm asking you, were you making an objection to her response?
My objection is non-responsive, Your Honor. She needs to answer the question.
Sustained. Ma'am, the question was, have you ever been arrested, thrown in jail at Lou Sterrett other than, have you ever been arrested, thrown in Lou Sterrett and then had the charge dismissed that was expunged?
Yes.
And the charge was for striking me for family violence, correct?
Slapping you. Wherein I called the police on you because you were coming after me, but I got arrested because I slapped you.
Is answering the question.
And you were also thrown in the drunk tank when you were in jail. Isn't that true?
No.
Well, the record will speak for itself. Your Honor, I'm sorry that we have to waste your time with this. I'm asking that my attorney's fees on Exhibit 11 be granted because I've spent at least 6 hours in these last 2 hearings alone. I've spent over 20 hours, at least 20 hours on my motions. I understand that 950 an hour is more than most family law lawyers ask for, and I asked you could reduce it in your discretion. I also asked that Ms. Leegee not be placed in contempt of court, not be thrown in jail, but be found that she has violated the decree and that this judge enforce the van rule and require her to hand me the keys to the van when it's my visitation. And it's up to her to pay for the van insurance. And again, I have made an open offer to pay for half of the insurance of your van that the 142 Special Needs Trust has a lien on. It was granted to you. One last question. Was the van at issue granted to you as part of the divorce decree?
We cannot find the title.
Objection, Your
The
Honor.
SEC has a lien on it.
Miss Leegee, stop speaking. Mr. Leegee, you've run out of time. Miss Leegee, you have exactly 1 minute left.
Your Honor, nothing in the decree authorizes uninsured transportation or requires me to violate Texas law. I am not that. I did this in good faith for everybody in getting on that van. Mr. Leegee also has had an incident report wherein he had kicked down the door during a previous MSA Zoom mediation, wherein he kicked down the door at my home, at our home at the time, and 4 policemen came and they escorted him off of the property. There is a pattern of I request that you make us use our family wizard to communicate because it is constantly coming through emails where he says he calls me Mia, a stripper name he made up, or he's thrown $20 bills at me in front of our son. Here's your table dance money.
Okay, Miss Leegee.
Okay, I'm sorry, I'm done.
You just.
I just, Your Honor, I just request there is no
Ma'am, you ran out of time. I just want you to calm down, okay? Just calm down. I'm not in a position to pass judgment on either one of you. I just want to make sure that I say that because I don't want either of you to feel like you have to defend yourself to me, okay? I just need to know, and now I'm going to unmute you, Ms. Legy. In the agreed judgment on page 44 and 45, I want you to turn to that.
You want me to share that for you, Your Honor?
Well, I don't know if she'll be able to see it. It's so small unless you enlarge it.
Hold on.
Does that work, Your Honor?
Okay. Thank you. Ms. Legy, can you see the screen?
Yes,
Okay.
I have it. I can't.
Joe, could you give him that case number? No, it was, Armas and Castillo. I gave him your email address.
I did. Go ahead. I mean, I have it somewhere, but go ahead.
Oh. The bottom, and he has it pulled up and it's highlighted. This is the part that I want to draw your attention to on page 44. It is ordered that Angela Lynn Legy has the duty to apply for, as applicable, Medicaid, Medicare, Medi-Cal for RML by February 21st of 2025. All I need you to do is just answer my questions, okay? Did you apply for Medicaid, Medicare, or Medi-Cal by February 21st of 2025?
Yes,
Okay. What was the date that you applied?
I applied. I don't have the exact date. Medicaid, it's I always renew. SSI, it was when I was talking to Eric, we hadn't even finished the decree yet. And I said, I can't go any further, Eric. The screen says, if you don't get the applicants, or Rebecca's, consent, you cannot move on any further.
Okay. You said something. You were legally unable to apply for SSI. What did you mean by that?
Because guardianship was in the courts. I'd already filed for guardianship starting in January. I could not legally apply because I could not prove power of attorney, legal representative, or legal guardian. She was already an adult. And I was going by what it said on the computer website when I was filling it out, and also as of January 26th, what the telephone conversation was.
Okay.
Your Honor, this decree was signed in March of 2025, after my daughter was already 18 years old.
Right. She turned 18 January 21st, 2025. She's now 19.
Okay.
Once she became an adult, from what my understanding, you cannot apply until there is a court legal document stating.
Okay.
The issue was Medicare only, Your Honor. She was already on Medicaid.
So the Medicare, Mr. Legy said that you applied after this action was filed. What did you apply for?
I applied for SSI. There is an exhibit where it shows there's a date on that exhibit of February 24th. I applied. I couldn't move forward on the website. I asked for them to email me documents, and there is an exhibit, but hold on.
Okay, wait a minute. Let me make sure I follow, because you said you were unable, you were legally unable because you didn't have anything in court, but now you're saying you did apply for it?
No, I tried to apply. So him stating that I have not tried. Exhibit 5 is a document I submitted, and it's dated February. If you look at the very top, it's very small. I asked for several documents and they mailed them to me, and each one of them said, I need proof.
Okay, so let me ask,
Documentation. So I was trying to, but I legally couldn't. Our daughter was already an adult. I legally could not show proof.
what is the status right now with the guardianship case?
Mr. Leachy contested the
That
end
wasn't my
of
question.
May.
Question.
It
What
is-
is the status?
It's pending.
Okay, do you all have a court date?
My attorney withdrew. She does not handle contested guardianships. I did not think Mr. Leachy would contest. She withdrew. Now I need to find, and I spent $3,500 on her.
Okay.
And now I
Yeah,
need to
question.
find,
Hold on,
I need to hire another attorney.
Ms. Legy. What is this? You said the status is pending, okay? Listen
Yes.
to my question. Is there a court date pending at this time? Yes or no?
I do not know. I don't have an attorney to help me.
Okay, Legy, if you know, is there a date pending?
Your Honor, there is not a date pending. I have the Ashmore Law Firm representing me because usually I abide by the rule that Abraham Lincoln said, a lawyer that represents himself has a fool for a client, okay? I just didn't want to hire Lisa McKnight for something like this. So Shep, I can't remember Miss Ashmore's associate. We are in the process of starting discovery and depositions in this case and asking for a trial setting. We're in probate court number 2, I believe it is. And it takes a while. The probate court moves at its own pace. But clearly, Larry Friedman and Mary McKnight and Lisa McKnight all entered this agreement, knowing full well that it is not uncommon for an adult who has parents that you do not need a guardianship, Your Honor, to apply for SSI. And what she hasn't shown you is any applications and denials. She showed you a letter that came from it, but no denials, nothing, no application was actually sent and presented to this court as evidence. She just has one letter that was dated the 23rd of February, and it doesn't say anything on it. There's no application ever provided or any denial of it.
I have a question for you. Are you able to apply?
Am I able to apply? I'm sure that I could, Your Honor.
I think, and I know the court order says she needs to do it, right?
Mm-hmm.
But if there is no rule or anything out there, and I'm not familiar with SSI laws or anything like that, I'm just speaking out loud. If there is nothing that says you are not allowed to do it, would you go ahead and apply for SSI?
Well, I don't want to step on Miss Leachy is the one that has the responsibility. If she's more than willing to say in open court that she's going to let me have that obligation and saying that she no longer wants to apply for Medicare and SSI on behalf of Rebecca, I would love to do that. I didn't believe that it was my place to just unilaterally apply for these benefits that my daughter's losing without the court's blessing.
Okay, Ms. Leachy, are you willing to allow him to go ahead and do the SSI?
And Medicare?
Yes.
And Medicare? Okay, so.
Yes, I do have an exhibit stating Becca, once she turns 21, she will transition. This is from WellPoint Medicaid. She transitions to Star Care Plus.
Leachy, stop talking. I'm trying to help you in this situation. I can't help you if you keep talking.
Okay.
If you are you willing to, let me just make sure, because I really wasn't clear on your answer. Are you willing to relinquish that duty to Mr. Leachy?
Yes.
Okay, that'll be great moving forward because we won't have this issue anymore. It's on the record that you agreed to it. What I have to do though today is based on today. So what I'm going to do is take this under advisement because I need to take a thorough look at each one of the exhibits. And I'm going to go back and review this transcript before I make a decision on what my ruling is going to be in terms of the allegations of violating the order as well as attorney's fees. You both understand?
Yes,
Yes,
Your Honor.
Your Honor.
Okay, and I have a 48-hour rule. So you'll get a ruling from me. Today is Monday. You'll get a ruling from me between today and Wednesday. It will not go beyond Wednesday. I have a 48-hour rule, okay?
Do you need a proposed order regarding the Social Security application and Medicare application provided to you, or will you do that yourself?
A proposed order?
Order, this way, if when I start applying for it, she may make an argument that I didn't agree to it, and then I'm gonna have to pull this transcript, which is gonna be, you know.
No, no. I am going to, it's on the record.
Yes, it is.
She agreed to it. So it's not going to be any of that. Only thing
Okay.
I need a proposed order is a ruling for today. And you can just make it granted or denied and leave a blank for the attorney's fees.
Will do, Your Honor.
I do not agree that he fills out SSA 788 because that is giving instructions for a third-party institution to take care of Becca. I do not, SSI, yes.
Okay.
I-
So the agreement is for SSI and Medicare.
Medicare.
It's only those two, okay?
And then, in that application, I will be applying that any income that my daughter receives goes into her special needs trust.
And
I will
that's
not
fair.
receive it, and Angela will not receive it.
And that's fair. It's for her benefit.
Yes.
Correct.
All right. Are there any questions before we leave for today?
Can we have temporary relief? The trust, SNT trust is waiting for.
No, ma'am. And I'll tell you,
Okay, there will not be insurance on.
no, there will be no temporary relief because the only thing that is before me is his motion for enforcement. If I go into anything other than what is before me, I am in violation of the law because he has a right to defend himself. I cannot do that. So if you want something on a temporary basis, there's a mechanism that you go about doing that. It's just not in front of me here today, ma'am. And I can't give legal advice, so I can't tell you what that mechanism is. You will have to consult with an attorney, but there is a mechanism for what you are seeking. I just cannot do it today. Does that make sense? Okay. Well, thank you all for your time. Thank you for your patience, and I'll get a ruling back out to you, like I said, no later than Wednesday, okay?
I apologize, and thank you for your time, Your Honor.
No worries. No worries. You all have a good day.
Bye-bye.
Bye-bye. All right. There was the ones that were set for 10:30, they're just, well, one person is just logging on. Did anybody check in on that 10:30? It's via Zoom. Let me see. All right. Yeah, motion. That's odd. Um, okay. I'm going to admit him. Okay. Good afternoon, Mr. Reyes.
Hi, ma'am.
Hi, are you still represented by Attorney McMichael?
Yes.
Okay, because nobody has, this case was set for 10:30 and, okay, here he is. Let me see what's going on. Hi, Attorney McMichael, how are you?
Judge Bailey, good to see you.
Good to see you too. Were you all scheduled at a different time and I just didn't know about it?
No, right now, 1 o'clock.
Okay, because it has 10:30 on my docket, so, yeah.
I think
Oh,
the order to appear says 1 o'clock. Yeah.
okay, the order to appear does, but the docket itself, it says 10:30, and I was about to freak out because I'm like, we've been on Zoom this entire time and no one has checked
Oh
in.
no. Oh
Okay.
no, no. Okay.
Okay, well, you all are right on time. So I'm going to give an opportunity for mother to appear. She's still represented by Attorney Rivera.
Oh no, no. Ms. Rivera withdrew at the end of the divorce. You signed her withdrawal.
Oh, I
Yeah.
see. I see it.
Yeah.
Okay, so she's representing herself now.
I well, yeah.
Well, as far as the
Officially,
record
yes.
goes right now, she is.
On the
Okay,
record, yes. Yes.
and have we done a rights hearing?
No, and that's what this first one is gonna be. Yeah.
Okay, great. So we've been running our docket all day since 9 o'clock. So we're gonna take a break that will give
Understood.
Ms. Reyes an opportunity to appear, and I'll be right back. Okay.
Okay,
Okay.
thank you, Judge.
Thank you.
Do you know how to put it on you? Show you. Just like where it says mute. Yeah.
Okay, we are back. All right. Attorney McMichael,
Yes.
Ms. Reyes has not shown up.
Okay.
So,
Well,
do you have a capias you would like for me to sign?
yes, I would like to request the court to issue a capias. And how would you prefer I send that to you, through the court coordinator?
Yes, please. It'll get to me faster.
Email, right?
Yes.
Okay. Yeah, I will do that. I was hoping we would be making progress, but okay.
Okay. Well, it was good to see you.
Good to see you despite the circumstances. I appreciate it. Thank you very much, Judge. Have a good day.
You do the same. Thank you, Mr. Reyes.
All right.
All right. So court is done for today. We